Because
So your matter is not listed. Your matter is not listed.
but listed as disposal.
Listed as disposal, but it is not disposed of.
Disposal. Tag with that.
And our name has also been not shown.
Okay.
Item number 43. Orders matter.
So it should have come for orders or it should have come for admission.
My lord, it may, my lord, my lord, it's order, my lord.
Or order only. Right, Mr. S.K. Siddharth, learned counsel. Submits that WPC number 9652022 has been shown as disposed of, while the same is yet to be disposed of. He also submits that his name is not reflected in the cause list. He submits that both these matters, that is WPC, both these matters, that is WPC number 26912023 and WPC number 9652023 2022 pertains to similar issues, and both are in fact tagged together to be heard together, full stop. Let both the matters be listed together for orders after 2 weeks.
After 2 weeks, my lord, showing our name, my lord.
After 2 weeks, registered to reflect the name of Mr. S.K. Siddharth, the learned counsel, appearing for the petitioner in WPC number 965/2022. After 2 weeks.
My lord, with profound respect, your lordship, the order, interim order was not extended yesterday, your lordship. In item number 4, it was not extended,
Not?
not extended, your lordship. It has not been mentioned in
You didn't mention about this.
your lordship. Today, your lordship have dictated the order, but the interim order was not extended. It was continued up to yesterday, your lordship. This is the order.
Item number?
4.
Yesterday's item number 4. Let's check if his certificate copy is gone. He didn't take it.
এইটো ডিপজিটিয়ে পাইছে তাক মই কৈ দিছো
Okay, we'll correct it. We'll correct it. We'll put the interim order. But that was not, I mean, that was not mentioned yesterday.
I mentioned, your lordship.
Then,
Your lordship, it was dictated, but I think inadvertently, your lordship.
okay, maybe somehow something is, somehow it was left out. We'll correct it. We'll correct it.
Your lordship.
It will be uploaded today, corrected version.
Hey, please, your lordship, I beg to mention item number 23.
Item number 23.
Your lordship, similar matters are also pending, lordship. We intend to file an affidavit. Lordship we intend to file an affidavit. Lordship may allow us 3 weeks time, lordship. He is appearing for the petition.
petitioner lordship. That's a pending lordship. This matter may be tagged along with those matters.
Which matters were?
WPC 2519 of 2024.
WBC
2519 of 2024.
2519. The other matter you have filed affidavit.
Lordship, the issue has been settled by in another batch of writ petition where we have gone on appeal for one of the direction against one of the direction. It's with regard to the amendment made to the tax reimbursement scheme. scheme has been upheld, Lordship, but there was a direction for reconsideration.
So it has come back to this single bench again.
No, we have gone on appeal, Lordship,
Hmm.
that is pending. In the meantime, they have challenged their rejection order.
So we'll take both these matters together. Okay, Mr. B. Chaudhary, the learned counsel appearing for appearing for the respondent, Finance and Taxation Department, submits that another matter, WPC number 2519202524, with similar issue is also pending. He prays for tagging both the matters together, full stop. He further prays that he should be allowed 3 weeks time to file an affidavit in WPC number 6337/2025. Prayer is allowed. Let both the matters be listed together after 3 weeks.
Wait,
Yes.
Your Lordship, my lord, item number 45, my lord. Possibly your lordship may not like to take it up because your lordship had appeared at the
45.
45.
Yes. Okay. Item number 45. List before an appropriate bench without me.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 29 of today's date in this.
Yes.
Lordship, in this matter, we've received our paravoice and we'd like to file our affidavit.
Hmm.
We've also taken consent from the other side.
Okay. With the consent of the other side, Mr. Your name?
Lordship, Mr. M. Huya, Lordship,
Mr. M. Guia, the learned counsel appearing for
appearing for the PWD, Lordship.
for PWD. PWD has sought for 3 weeks time to file the affidavit in opposition in the instant case. Let the matter be listed after 3 weeks.
Much obliged, Lordship. May it please your lordship. With regard to item number 12, your lordship, and pray for an accommodation for.
Yes. Mr. D. Das, the learned,
For the respondent number 10, Lordship.
Mr. DJ Das, the learned counsel appearing for the petitioner submits that the matter may be adjourned
For
for
today.
This matter may be fixed after 4 weeks, Lordship. I am for the respondent number 10, Lordship. This matter may be fixed after 4 weeks, Lordship.
why 4 weeks?
Lordship, we file IO, Lordship.
Why 4 weeks?
Let it be 2 weeks, your lordship.
The matter may be listed after 2 weeks. He submit the learned counsel submits that he has already circulated a mention for a mention memo for adjournment of the matter.
Much obliged.
Yes.
Your lordship.
Hmm.
Lordship, I beg to mention item number 48 of today's list.
48.
Lordship. It's a consent case, Lordship.
48.
Yes.
Yes.
The order has been complied with, Lordship.
Order has been complied with. So you want to withdraw it? Okay. Mr. M.K. Bora, the learned counsel appearing for the petitioner, submits that in the instant case, the order has already been complied with. Therefore, he prays for withdrawal of the matter. Full stop. Mr. MS M. Bormon appears for respondent number 1 and 2. 1 and 2. The matter, the case is dismissed on withdrawal.
Obliged.
This is my lord. I'm praying for some accommodation with respect to item number 18, my lord, of the daily list.
Item number
Daily
18.
list. We have taken the consent with the other side, my lord. We'd like to file our affidavit in opposition, my lord.
Okay, Mr. B. Borwa, the learned B. Borwa, H. Borwa, the learned counsel appearing for Texas Department submits that the matter may be listed after 2 weeks as he is going to file an affidavit. File an affidavit in the instant case. He submits that he has already taken consent of the other side. Let the matter be listed after 2 weeks.
Lordship, I'm for the petitioner in this case. Lordship, but date may be fixed.
A similar player paired for item number 21 as well, my lord. Same petitioner,
21 also.
my lord.
Okay, 20 or 21 also.
Lordship,
Take-
date may be fixed.
Your name?
P. Jalan,
P. Jalan is present for the petitioner.
petitioners in both the cases, your lordship.
Obliged.
Please, your lordship, I beg to mention item number 44. for adjournment of 2 weeks.
Yes,
Item number 44.
yes.
Adjournment of 2 weeks because because of personal difficulty of my senior. I'm appearing on behalf of Mr. A. Tiwari.
MS so and so the learned counsel appearing for Mr. A. Tiwari submits that he has some personal difficulties to conduct the case to the
Your Lordship,
praise for 2 weeks time.
interim orders passed.
2 weeks time, prayer is allowed. Interim order so passed earlier shall continue till the next date of listing.
Obliged.
Wait, your lordship.
Yes.
See, in item number 9, my lord, if I have to file reply to the affidavit opposition filed by respondent number 1 and 7. So, sir,
No, no, no. I mean, we'll see when the matter comes. This matter, I mean, no. We'll see when the matter comes.
We have pleaded lordship, but in item number 60, we have filed the additional affidavit in reply lordship. We may be allowed to take in.
60.
And lordship, may I pay for updation of this matter lordship if your lordship will permit?
No, no upgradation. So many matters are there. Why upgradation? Who is praying for upgradation? You're praying for upgradation. No.
I am for the petitioner.
No. So, you have filed an additional affidavit. So that has to be brought on record. It's already filed. Okay, you bring it on record. Bring it on record. I mean, we'll take it up
Yes, sir.
if time allows.
And I have already taken the steps, my lord.
Hmm?
I have already taken the steps. Yesterday I have taken the steps, my lord. All names have been reflected in the cause list, my lord.
You have taken steps.
Yes, my lord. One was for Union of India, my lord. Other is for state GST. State GST I have served extra copies, my lord.
Hmm.
And for Union of India, I have taken the extra post, my lord.
Okay, Mr. A.K. Gupta, the learned counsel appearing for the petitioner submits that he has already taken steps in the instant case or yesterday, that is on so and so, yesterday so and so. Let the matter be listed after 2 weeks.
Interim order, my lord.
Interim order so passed earlier shall continue till the next date of the listing. Mr. B. Chaudhary is present for the respondent.
Much obliged.
He is for respondent. Take his name also, respondent to entry.
Much obliged.
In this case.
This matter was not part heard. I don't know why this was listed as part heard.
The here, the requests were called for, then the records have been received today, So, since, since it was not hard at length, probably that was.
No, it was not part heard. We have not kept it part heard. Yes, it was heard for some time. Then some confusion came. I mean, about some records and all. Then we call for the record.
The records are here,
That is-
so lordship may fix a.
Record has come, Mr. Nayak.
Yes, today morning I see.
Hmm.
So lordship will fix a date on any hearing date, so then the matter can be disposed of. So it will take time.
Okay, heard Mr. R. Day, the learned counsel appearing for the petitioner, also heard Mr. P. Nayak, the learned additional advocate general appearing for GMC, and Ms. R. Chaudhary, the learned counsel appearing for respondent number 5. Mr. P. Nayak, the learned advocate general, additional advocate general submits that he has already received the records pertaining to the instant case. Full stop. A joint prayer was made that joint prayer was made for listing of the matter in hearing column. Let the matter be listed after 3 weeks.
On a hearing date.
After three weeks.
Date may kindly be.
After 3, I thought date 3 weeks. For hearing, huh? For hearing.
Lordship will say the last order. My lord, I am the petitioner. I will to argue. My lord, till now, my lord, they have not complied with the order of this honorable court. They were asked to file affidavit specifically, and they have not filed any affidavit. Your lordship kindly see order 33/2026, my lord.
33.
My lord, 30. Then next.
$33.
2026.
2026. Yes.
Then list the matter again on 6/6/25
Hmm.
and affidavit regard the filed by the circle officer Titapur Revenue Circle on or
Hmm.
before the next date.
So who is appearing?
Then next, my lord, your lordship kindly see.
Then 36/5.
5/20.
Yes.
So till today, my lord, they have not been complied with that.
My lord, regarding this issue, my lord, a PIL is pending, my lord. A PIL is pending.
What this issue? How this issue is involved?
My lord, establishment of stone crusher
Hmm.
regulation, my lord. And
Whether that will be applicable or not, that
Yes.
that much you need to say.
this court has asked us to. take-
Yes, you need to only get the instruction whether that particular act will be applicable in the instant case or not. Instant case means his stone crusher.
Hello.
So though that much you need to do.
Yes.
So why have not filed affidavit?
Directed whether it was notified or not.
It was notified.
Whatever. I mean, there was a direction given whether in compliance of that. Why have not you filed the affidavit till date? This was simple thing. Whether it is applicable to or not, or whether it's notified or
Our
not.
instruction is, my lord, not applicable, my lord.
Hmm?
It is not yet notified, my lord. Our process is going on, my lord.
So it is not notified, then his crusher is not covered by that. Then
My lord, it's a very serious, my lord, health hazard case, my lord, within, my lord, 50 meters, we are, our residents are there. Already they are, my lord, they are permissible, they have exceed, my lord. So immediately, my lord, your lordship kindly see, we are facing the trouble, my lord. But last so many years, this case is pending, my lord.
it's from 2014. You are appearing for whom?
Government, state government. my lord.
So what state government is doing till date?
My lord, actually, impugn order was passed by the pollution control.
Huh? Now, should this court modify the order passed on this 33/2026 after hearing all of you?
My lord, pollution control board.
Direction was given to whom?
Circle of
Circle.
Then are you not supposed to comply this? Why don't you say in the affidavit that we are not concerned? The pollution control board has given the permission to establish this. They are only concerned person, so we are not concerned. Why don't you file an affidavit? File an affidavit to that extent. You file an affidavit to that extent and other information,
I will-
whatever was sought for. But my lord means what? When?
Fine.
You will file when? Why you have not filed till date? In spite of these two orders?
Last order only instruction.
Mr. Bokolial, I mean, if you want to explain this kind of thing, take some excuses. Then we did for 2 weeks. I mean, after direction was given in March.
Will file. 2 weeks time. we will-
So much of lethargy will not do. Lethargy, clumsiness, what is to be said? How much time you tell me
2
correctly?
weeks, 2 weeks. Within 2 weeks.
Within 10 days. Within 10 days you file it. Heard Mr. TJ Mohanta, Lawrence Senior Counsel, assisted by so and so. Also heard Mr. P. Hajarika for respondent numbers
10.1 to
10.1 to 10.3. You are appearing for whom?
the beneficiary.
Beneficiary. Okay, respondent 1, 10.1, 10.3, and Mr. Bokolial.
My lord, I am appearing for only 2, 3 and 4.
Respondent number 2, 3, and 4. Full stop. In spite of the order of dated 33/2026 of this court directing the circle officer Titapur Revenue Circle to file an affidavit. To file an affidavit clarifying the issue whether the private respondents complied with the mandates of Rule 2, mandates of 2(1), 2 small 1, and Rule 2, Roman 5 of the Assam Stone Crusher Establishment and Regulation Rules 2013. Full stop. Further time was given on 6/5/2026. However, till date, no affidavit has been filed by the concerned circle officer of Uttarboard Avenue Circle, Mr. Bokolial, appearing for the government, prays for further 2 weeks time to file the affidavit to that effect, full stop. Looking into the matter that the same is pending from 2014. A last opportunity for filing an affidavit is given to the state respondents. Full stop. It is directed that state respondents will file an affidavit as directed in the aforesaid 2 orders within 10 days without fail. Full stop. Let the matter be listed after 2 weeks. You file it, whatever you stand, you file it. Why do you take so much of time? 2014 it is pending.
Item 4.
I am appealing for private respondent number 6 and 7, my lord. Petitioner is not appearing, my lord. Last opinion also not appeared, my lord. My lord,
None appears for the petitioners when the matter was called for. It is seen from the records that on the last occasion also, when the matter was called for, none appeared for the petitioner. Mr.
M. Sakya, my lord.
M. Sakya is present for
Respondent of 6 and 7.
respondent numbers 6 and 7. MS S. Kemprai, the learned standing counsel for KASC, is present for the respondent numbers 2 to 5. G. Hazarika for respondent number 1, full stop. On the next occasion, then let the matter be listed after 2 weeks. On the next date, if the counsel for the petitioner does not appear, the matter shall be dismissed.
Apply.
5.
May I please, your lordship?
Yes.
Your lordship, respondents file affidavit, lordship. And they admitted the amount, lordship. This case is, lordship, petitioner is the agent claiming to financial year.
So nothing remains in this matter, it seems.
Shift the apostille and financial sanction, your lordship. We are trying to release in this current financial year, lordship. That is subject to receipt of financial sanction and fixation of billing, your lordship. Finance department also a party here, your lordship. I have stated in paragraph number 10 and 11.
So you have filed an affidavit. What is your latest instruction? Today is what? Today is 20th, 22nd of May. And that last thing that you have annexed was 28th of April, almost 1 month.
No, your lordship, we have filed on 11th of May.
No, 11th of May, madam, but like document that you have filed, it was of 28th of April.
Yes, your lordship.
Then,
True, your lordship, but
then
we have.
Then 1 month, if you do not get sanction or if you do not get any follow-up instructions, then how this court is going to adjudicate this matter?
We have not received that we have not received the financial sanction and FOP, your lordship.
Who is appearing for the finance? Finance is a party?
Amount is not reported, lordship, so maybe dispose of the time being, lordship. Yes.
Mr. Mani, Mr. Nayak, money is admitted, the proposal has been given, only this financial sanction or whatever is required to be released, is required for releasing this amount. You have, they have filed an affidavit saying that the money is due and they have sent a proposal also. But proposal sent to whom? Director to the Secretary of Social Justice and Empowerment. Where is the document that you have sent it to them, Finance Department?
28th of April.
Lordship, for that, I have to take further instruction, your lordship, whether finance proposal was sent to the finance.
Because this, from this copy, it cannot be make out. It cannot be made out from here.
Yes,
But you have, I don't think you have sent a copy to this finance department.
Specific approval of the finance department may not also be required also, because these days, not if higher secretary of the department is also the competent authority to give finance.
They can do it.
They can also do it. So later have they instructions.
You take the instruction, we'll fix it in the next week. Heard, Mr.
Joan.
So in so learned counsel for the petitioner also heard MS Ardeka, the learned counsel appearing for
Social Justice and Empowerment Department.
department. MS Deka submits that she does not have the updated instruction about release of the money. She prays for 1 week time. 1 week time is allowed. Let the matter be fixed on 3rd of June.
Obliged.
Item 6. My lord, you will see the last order, my lord, 2/4/2026.
Lordship, here the DSC doesn't have a role, your lordship. I may be
Who
granted,
doesn't have role?
DSC, the Director of Secondary Education, your lord. So I may be granted some time to obtain the instructions of the Inspector of School, your lordship.
But, last opportunity was given to the learned counsel of secondary education department to file an affidavit.
Yes, your lordship.
Then-
From 22/7/2024, they have not filed affidavit and school is being closed. ADC has filed an affidavit, my lord, that for academic.
See, this is his land and building. You have taken it to run a school
Yes, your lordship.
on the basis of a rental agreement that expired. Now you are not running the school. The land is lying vacant. Land belongs to them, and you are not doing anything.
I'm seeing the photograph, today's morning photograph, this is my lord. This jungle, my lord.
Lordship, a last opportunity, your lordship, the instructions from.
Last opportunity has been given already.
Your lordship, from the Inspector of School, your lordship. From the Inspector of School, your lordship.
What?
Obtain the instructions, your lordship.
Whoever you take the instructions, that's not this court's concern. You should take the take the instruction and place it before the court. Where is that?
Nothing, they have not filed affidavit till date, my lord. And since 1977, my lord, the rent has not been paid, my lord. October 77, sir.
We'll call your director to explain the matter before the court. What is happening?
It's a welfare state, my lord. And school is closed, my lord. I've produced that letter from the inspector of schools, my
It
lord.
was with him. It was with the director of secondary education only.
Yes.
Who was running that school?
School was director of secondary education. my
That
lord.
agreement that you entered into with whom?
Inspector of schools, my lord.
The inspector of schools ultimately the departmental head will be director only.
Yes, yes.
Last occasion also, that specific direction was given, that the last opportunity was given. You do not follow court's order. You are too big, Department of Higher Secondary Education. You are too big. Heard Mr. J. Roy, the learned counsel, assisted by Mr. B. Mr. R. Hazarika, the learned counsel for the petitioners. Also heard your name,
Terangpi, Your Lordship.
H. Terangpi, the Standing Council for Higher Education Department,
Second,
Secondary Education Department. Full stop. On 2/4/2026, MSP Das, the learned counsel appearing on behalf of Secondary Education Department, prayed for some time to file an affidavit in the instant case. However, though a last opportunity was given to file an affidavit in the instant case, the same was not done as yet. Full stop. When are you going to file it, or otherwise we'll call the director?
Lordship, on the next date, if the affidavit or any instructions has not been provided by us, then on the.
Let the inspector of schools appear, my lord. Because page 60, my lord, the inspector of schools has passed an order that, my lord, the school has been closed, my lord. From 20.
Okay, taking into account the facts of the case, this court is of the opinion that the personal appearance of the inspector of schools, Jorhat, respondent number 8, is necessary in the instant case for proper adjudication of the matter. Full stop. Therefore, it is directed that on the next date fixed, that is on 16th June, the inspector of school, Jorhat, shall be personally present in the court to explain the status of the case. Let the matter be listed on 16th of June.
And also go file an affidavit, my lord.
So let him come.
My lord, sir. Obliged.
Let him come. We are not giving any opportunity to file the affidavit now.
Fine.
Otherwise, they will come back and say, we have already filed the affidavit.
Yes.
His opinion is not required. Mr. Nayak, come in. There are certain mistakes committed in filing this IA by you.
They are trying to.
No, not they are trying to. I have gone through this. How can you file this application
No, Lordship,
like that?
Lordship, may kindly see the order by which I was allowed to,
No, I mean, see, the order may be whatever the order, we are not on the order, but see, when you replace somebody,
Yes,
so now the state will be represented by the secretary,
yes.
correct? So secretary, you are filing an application only to bring in secretary. But what about the writ petition?
No,
What
no,
about the
no.
rejoinders? What about the
First,
things?
Lordship will allow this petition.
Correct,
Lordship
that
will direct to implead the person concerned.
then implement the,
Thereafter, he will file an affidavit endorsing the averments made in the writ petition. That
then,
will come later.
and
Lordship.
then you'll have to file an amended writ petition also,
Yes.
or otherwise you'll have to file an additional affidavit saying the statements.
Subject to Lordship allowing this IA Lordship, I have to file.
But ideally, it
amended
could have been filed together.
Lordship, that is why Lordship, what he technically did, Lordship filed this reply, Lordship, in the writ petition, not in the IA. Lordship, may kindly say, yesterday also I said this reply in the IA, Lordship, but it has not been filed in the IA. Lordship, may kindly say this is writ petition 6107/2022. That is why he raising this objection. He should have filed this objection in the IA if he is going that technical, Lordship. This is an objection filed in the writ petition. So what I am submitting, Lordship, these grounds are too technical, Lordship. May kindly see the first ground, Lordship.
Yeah,
This is-
that I have seen. No, no, but one thing is, Mr. Nayak, that once this person replaces, secretary replaces the other person. So the whatever that amendment you'll have to carry out.
Then you will have to require.
Amendment have to carry out.
Amendment in
So
the.
you'll have to file by way of an amendment
One
application,
affidavit I have to file.
or you'll have to file this.
Yes,
thing.
earlier, Lordship, the affidavit was filed by the director, I mean the forest head, Lordship. Now it will be filed by the secretary, Lordship.
So all the statements and all in the
State-
petition has to
state
be.
will be, I mean, approved by the secretary, Lordship. Just single that affidavit only, Lordship, nothing else.
No, you have made statements in the thing, na?
Lordship, may kindly see
Re-
paragraph 4.
Let us see the repetition.
Yes. Lordship, here his objection is that the applicant has supports the averments made in in paragraph 1 to 5 of the application. He is not supporting the averments made in the writ petition. That is the ground, Lordship. Lordship, what I am submitting, Lordship, once he is implemented, Lordship, he will definitely support the averments made in the writ petition. And to that extent, Lordship, he will file one affidavit. If Lordship comes to the affidavit file along with the writ petition, Lordship. At page 22, Lordship. This was by the PCCF, Lordship. Now it be.
That this paragraph has to be changed.
Yes, Lordship. That is the only requirement, but that will come only after the IE is allowed. So that is one ground, Lordship. Belated, Lordship, so far as that belated, highly belated, Lordship. Lordship, may kindly see in the order passed by the learned coordinate bench, Lordship, in page 16, Lordship. Page 16, paragraph 3.
Page 16
Yes, of the IE law.
of your IA.
Yes. Paragraph 3, Lordship. Considering the importance of the matter involved, this court is of the view that the interest of justice would require giving an opportunity to the petitioner to file appropriate IA in this regard, as dismissal on the petition on the ground may not serve the interest of justice. So I was allowed by this
Yeah,
honorable.
that was allowed.
That is one, Lordship, belated. Second ground, Lordship has already seen. Third ground is Lordship.
Now what you'll have to do is like, I mean, if at all it is allowed,
Yes.
then you'll have to file an additional affidavit
One
bringing,
additional affidavit.
bringing.
In fact,
all
two
these things.
affidavit I will have to file, Lordship, one amended cost title.
Yes,
and
Mr.
one
Tiwari, you have anything to say?
Mr. Let's.
Since I appear for the state of Tamil Nadu, my lord, we are not opposing impleachment for the simple reason. Impleachment of the state of Assam would strengthen our case on maintainability. We would be arguing on maintainability because Article 131 would apply with full force.
Lord-
So anyway, my lord, that is,
Lord,
we are
respect
not
of the
opposing.
state of Tamil
It's the
Nadu is
Nachia
concerned.
temple which is opposing. So my lordship may hear the Leonard Senior Council.
But
And
they
then
are
for the
not
temple
objecting,
authority.
that statement is already there before.
Let's.
That has already been observed. by us.
Yes, yes,
It's only.
If your lordship will permit me to appear by
yes,
VC.
yes.
Respondent number.
Yes.
Would your lordship, first thing, your lordship, the notice the objections which have raised, that this.
No, first of all, Mr.
Arpudam.
Yes, this time was allowed to file objection to the IA,
Yes, that we have filed it.
but you have filed it in the writ petition.
In any case, if your lordship will look at the reply, it says is a reply to the application. That's only a
No, that
technical
is
part.
different, but there is a format which is followed.
That we will.
If you are,
that we can have it corrected.
if you are taking certain technical grounds.
No, my objection is.
No, which looks to this court is quite hyper technical. And then you are again, you have filed, you are supposed to file an objection to the IA only, but you have filed in the writ petition.
I am not so much as to the implement part of it. My only proper grievance is, even if this application is allowed, the main objection which I have taken earlier, that this petition is not properly instituted, would not be covered. So they should correct themselves as far as what the application is they have filed and certain other things which they are required to do. Which they are not
That once say, usually what happens, usually what happens, if there is a correction required in the writ petition, in Gauhati High Court, what if the procedure followed is that IA has to be filed, then IA has to be allowed, and once IA is allowed, then they will file the subsequent application.
Very well, Millet, if that's a procedure, Millet, I cannot say anything about. Second, one more thing, Millet, as for the delay, etc., I'm not that's in your lordship's discretion. They
court
filed
has got
it,
a
it's all right, that's in your lordship's discretion. The
yeah,
other
delay-
thing in Millet, now this application is filed saying that the secretary in the department would substitute the principal chief conservator of forest as representing the state. Ordinarily, Millet, the secretary in the department would be competent to represent the department. But this is the case where the state of Assam is purporting to file a petition against the state of Tamil Nadu. Whether under the conduct of business rules, which I don't have, which I have made a request that your lordship may call for it and show, whether it will be the chief secretary who would be the competent person or the secretary in the department. Because I don't want to again make an objection later. Because he has not placed how the secretary is competent to file a petition against another state. Ordinarily, he can represent the department. In ordinary litigation, I have no grievance. So that I have no access to the business rules. So therefore, Miller, you should satisfy your lordship whether the secretary is the correct person or it will be the chief secretary when the state is purporting to file a petition as against another state. That
Chief Secretary is not required to represent in all cases for the state.
Not all cases, Miller. When the state is purporting to file a petition against another state, then the secretary in the department is the...
If state files also, secretaries are empowered.
Very well, Miller. Ultimately, if they are able to satisfy your lordship eventually, that as per the business rule, secretary will be sufficient or chief secretary is not required, let them see that and be satisfied.
Is there any business rules that you have?
Lordship, Assam Rules of Executive Business,
Mm.
1968.
Mhm.
Here in the definition clause, Lordship, secretary has been defined as secretary means a secretary to the government of Assam and includes chief secretary, additional chief secretary, principal secretary, special commissioner, commissioner and secretary, special secretary and additional secretary, a joint secretary, a deputy secretary and an under secretary. All these are within the meaning of secretary, Lordship.
But is there anything that who will represent the state?
Lordship, who will sign on behalf of the state?
Yes.
If Lordship comes to,
Is there an
12,
authority, specific
Rule
authority
12,
required?
Rule 12, Lordship. Rule 12, every order or instrument of the government of the state shall be expressed to be made in the name of the governor and shall be signed either by the secretary, an additional secretary, a special secretary, joint secretary, deputy secretary, and under secretary or such other officer as may be
Authorized.
specifically empowered. So that is the rule, Lord.
Yes.
Plus, is one thing to say the secretary can file authenticate orders, etc. My is the thing that what they will have to satisfy your lordship eventually also when the matter is taken up for final hearing is that a secretary can file a petition representing the state against another state, or it would be the chief secretary. That I don't know whether there is provided for in the conduct of business rules or it is not. If it is not, then what is the position? That's the only aspect that your lordship may have.
In that situation, may I submit, Lordship? Probably he is
If they
referring.
produce a conduct of business rule, I may be able to have a look at it and assist your lordships. But since I don't have access to that, Miller, let them produce it, Miller, then at the hearing, Miller, your lordship may take a view. Because one of the grievances submissions which I made at the hearing of the case was this writ petition is not properly instituted and is liable to be rejected for that reason. It is in that context, Miller, the matter was fully heard. It was at the end of the hearing, Miller, then he made a request and the court, of course, said you make an application. I am no grievance about that part of it. One more thing that your lordship may have a look at it. I don't want to make that argument the next time. Would your lordship have a look at page 8 of the writ petition?
Page 8.
Page 8 minutes. Paragraph 1 of the writ petition minutes.
Paragraph 1.
Yes, minutes. Your lordship have got that page minutes?
Yes, yes, it's page 5, it seems.
Page 5, I'm sorry, Millet, it is
Hmm.
page 5. Your Lordship will have para 1, Millet, the petitioners before your Lordships are the principal chief conservator of forest and the head of the forest as well as the chief conservator, warden, etc., entitled to safeguard the privileges and part 3 of the Constitution of India and the legal rights. So, Millet, this is what the government in para 1 is concerned. Now, if your Lordship will come to the cost title of the petition, Millet, if your Lordship will come to, that's what the page? Page 1, Miller's cost title.
Hmm. Yes.
First petitioner, Miller, the state of Assam represented by the principal conservator of forest. Whereas the government is, this petition is by the principal chief conservator of forest. And now the secretary says, substitute me in the place of the principal chief conservator of forest. Insofar as the state of Assam is concerned, but there is nothing to say that the petition is by the state of Assam. Well, if they are amending, if they are to amend, let them take all this into consideration. I am saying only for the purpose not to find fault with it, that an argument in this regard, again, in the final hearing of the case, I don't want to.
Mr. Naik, you do one thing. You bring all those things on record by filing a reply to this.
Lordship, probably my friend is having some law settled by settled law, Lordship.
Correct.
That's why probably he is referring.
That is what. So all these things should come on record. So you bring that business rule also.
Yes.
Correct. Your business rule also. You reply to this saying whatever of the provisions, and then we'll consider this. That I think that will be better rather than lengthening it, because ultimately some objections has been raised.
It will only clarify one thing, whether we'll file this, reply in the petition or in the IA.
I think basically they have filed this objection to the IA only. But though they have written petition, it is objection to the IA only.
Is an objection in the
IA only. So they what we are thinking of, let them file a reply to your objection.
Very well, Millet.
Then they will bring on all these things record. Then you can go through this. Then in spite of that, if you have some objections, then you can raise.
Very well.
All right.
Actually, so far as I recall, both in Rajasthan and Karnataka cases, the chief secretaries had come for the state. So possibly, anyway, that is on 130.
Understand? It says they are trying to say that this is a dispute between two states.
That's why.
So that is
That's why 131 may not have the argument.
that is.
Lordship.
But you could have done that also, Mr. Nayak. Why didn't you do that? That could have done. That would have.
If he has some difficulties.
That would have been more safe for you.
That can be, yes, now that can be done now.
Yeah, but this says this your secretary definition of secretary includes principal. Chief secretary also.
Under secretary.
Secretary also.
All these are included.
So if state authorizes somebody through the executive business of rules, then nothing can take away their authorization.
That is my understanding also.
Let him place it on record, Millet. I will just have a look and assist your Lordship. It's not so much a technical objection. Ultimately, we want the matter to be decided in a proper manner.
Okay, we'll give them an opportunity to file an affidavit reply to your objection.
Lordship, if he is having no such technical objection, Lordship may allow this petition. Subsequently, he will not raise this.
No, you file a reply. Bring those things on record. Whatever the objections he has raised, then we'll pass an order on this. Okay, heard Mr. P. Naik, the learned Additional Advocate General, appearing for the state of Assam. Also heard Mr. A. Maria Puthari, the learned Senior Counsel, assisted by MS Otoli Kits, the learned counsel for respondent number 11. Mr. Tiwari, PK Tiwari, the learned Senior Counsel, assisted by so-and-so for respondent number.
Now, the state of Tamil Nadu and its officials, the numbers are.
For respondent numbers 2, 3, 4, 5.
2 to 6.
2 to 6. 2 to 6. 2 to 6. Mr. DJ Das for respondent number 8. Mr. Naik submits that since certain objections since an objection has been filed in the instant IA, raising various issues, he would like to file a reply to the aforesaid objection. He prays for how much time?
2 weeks.
He prays for 2 weeks time. 2 weeks time. Mr. Nayak is given 2 weeks time to file the affidavit file the reply to the objection. Let the matter be listed. Give us a date. When do you want, Mr.?
Your Lordship will have it in July, June. I will not be here in the country, I will be out of sometime in July.
Mr. Nayak, July?
If he has some problem, Lordship, it's okay, Lordship.
Okay, July, can you give us a date or we'll just put it in
Any
July?
date, any date that is convenient, your Lordship, in July.
Any date in the month of July?
Yes,
So we'll put it on 21st of July.
very well.
Let the matter be fixed on 21st of July.
Only one request, let him place on record the.
That has been communicated to them.
Very well.
That has been communicated to them. And whatever, issues that you have raised, that you have already detailed in your objection. So
Yes.
they will take care of that.
Very well.
Okay.
Grateful to your Lordship.
Item 8.
Please, Your Lordship, on last occasion, I was directed to obtain instruction in respect of the claim from the Kala Lord.
You have received it or not?
Lordship, our office has received, but I have got one letter, Lordship, mail, Lordship, that about that joint measurement, our office was never informed, Lordship. NHIDCL was never informed about the joint measurement process, Lordship. Normally, it should be informed, Lordship, because it is the amount of the NHIDCL. So, in the joint measurement, we have to invite.
Who has taken the joint measurement?
Only by the PWD department, Lordship.
So he is not PWD
No,
department.
Lordship, I'm not saying, PWD department has the joint measurement was taken. That's fine.
But usually what happens?
Usually, Lordship, competent.
What is this thing now?
Lordship, that is why I have got this letter, Lordship, that neither informed, so we are informing the Kala about that letter, Lordship. 15 days time may be given, Lordship.
My Lord, first
We
of
are
all,
not saying that he's not entitled, Lordship, but we have to inform about that measurement, Lordship.
No, you release the money. No. What? I mean, PW has done the measurement. What else you want? What else you want?
Lordship,
Why are you dragging the matter?
No, not bragging, Lordship. I need 15 days time, Lordship.
No, you don't. You will not be allowed. 15
Because,
days.
Lordship, that process, Lordship, joint measurement is to be done along with the NHIDCL, Lordship. That is our money, Lordship.
Your money. I mean, what? Let's see what
he
was
is the
there.
beneficiary on. He has nothing in the.
You have taken. You have already taken their property.
Yes.
Yes, that is why.
You
Lordship,
have
we
done
to
their
pay,
property.
Lordship. That is why, Lordship.
Then why haven't you done till date?
Lordship.
Why have not you done till
That
date?
letter-
Whether any representation was given to him? So show me the representation.
After, Lordship, 28.
First of all, my Lord.
No, show me the representation where you have given a copy to them.
First of all, I have filed additional affidavit in the year 2024,
Hmm.
annexing that. That copy was given to him also.
Hmm.
Thereafter, my Lord, the government filed the additional affidavit.
No, where is the additional? Where is the additional affidavit?
My Lord, filed by the respondent number 2, my Lord.
Huh?
Firstly, my.
No. You show me on record
My Lord.
that record about that measurement.
Yes. Kindly come to running page number 68, my Lord.
68.
Yes.
Yes, 68 was to.
This is junior engineer to the assistant executive engineer, and this document has been annexed by me with additional affidavit filed in the month of September 2024. That additional affidavit has been supplied to the Standing Council of the NHIDCL also, my Lord, firstly. Now kindly come to the.
Has he replied to that additional affidavit?
No. Thereafter, my Lord, kindly come to the order dated, my Lord. Fifth of December 2025.
5th of December 2025.
After filing of my additional affidavit,
Hmm.
Kala was given the opportunity to,
1 second, 5th of December.
yes, 2025.
1 second, one. Yes,
Last but third line, my lord. Warning was given to the Kala to file affidavit. And all these things are also communicated to the NHIDCL also from this honorable court. Following the personal appearance of the concerned official. Thereafter, my lord, kindly come to order dated 25th of June 2024. Twenty-fifth of June 2024.
Hmm?
25th of June 2024. 2 years past, my lord. Second paragraph.
Hmm.
Here also, the honorable, my lord, judge has given the warning. Casual approach adopted by the respondent's office in dealing with the matters where the constitutional, statutory, and human rights are at stake. It was passed in the year 2024, my lord. 2 years passed. Thereafter, my lord,
1 second, 1 second.
yes.
When did you receive the letter from them?
Lordship, the letter was written to the general manager and NHIDCL by the competent authority on 28 April 2026.
28?
26
After
April.
after a direction of this honorable court,
Hmm.
to forward it to the, my lord, by the Kala to the NHS. But prior to that also, in this honorable court, I have submitted those documents and the additional reply filed by the Kala has also reflected the same. my lord.
Where is the
That
document?
letter. Lordship, Kala has forwarded to our office on 28 April, Lordship. 26.
So Kala is responsible for such delay if it was not communicated since 2023. That is why order was passed, casual approach. This was given as per the order dated 7th of 4.
Wait, Mr. Nath, wait. So we'll do one thing. We'll allow them to do the joint inspection.
Yes, Lordship. That is.
Wait. Inspection within a period of time. And release the amount.
My lord, may I, in just one thing, my lord,
Hmm.
kindly come to page number 23 of the writ petition.
Hmm.
This was the earlier report at the beginning, my lord, when the acquisition was done. And at the bottom, my lord, if you see the 23 and 24 page, it was done by the executive engineer.
No, I understand that. I understand that executive engineer has done it, but has done it. But only thing is that like they were not involved in the inspection. They are saying that money will go from me, so I should have been also a party to that. Now there is some maybe some some kind of, I mean, what do I say? Some kind of negligency or whatever on the part of the authorities to forwarding this letter or placing this before them, right? Because maybe because they thought the matter is pending before this court, the matter is sub judice. Now, only thing we can do, see, we can do one thing, that a estimate has already been prepared by them, executive engineer. I don't think that in that estimate there will be a big difference if they go also. So in that case, let all of you be there, and after that, like whatever the estimate comes about your loss, that will be paid to them, paid to you. Now, what is the point of keeping this petition pending? You tell me.
Nothing, my lord.
So let three of you go there. I mean, already an estimate has been made by PWD.
That is correct.
So you also be there. Let them be also be there, and within a month they will go for this thing joint inspection, and after that they will release you the amount within a month. They will do the joint inspection within 2 weeks,
Well.
and after that another 15 days for them to release the amount.
That will do.
Hmm? That will do,
That will do.
Mr. Sharma. Because there is no point again, they'll wait, they'll come for instructions, this and that. Ultimately, some loss has been caused.
Yes, yes.
Correct.
Wait,
Yeah,
wait.
you also appreciate
Yes,
that.
yes, yes. You are not
So
saying
there is some loss and that has been estimated. Only thing is that estimation is you were saying that you were not involved. So you be involved there, and after that you release that amount, whatever. You be also there.
Well, but that the reply filed by them, they took the point that I am not entitled. The affidavit in
No,
reply.
that we have seen. No? I mean now
Yes.
they have issued this letter, isn't it?
That is correct.
Now they have issued this letter.
And the
That-
lordship, there is
that-
some damages,
Hmm.
and it was estimated by the PWD.
For 4 lakhs or something.
Yes,
So-
so they must have to pay, maybe a
Well,
little bit.
a little bit here and there. You estimate. I mean, do you go? Three of you be there and do the inspection and.
Well,
Okay, right, heard Mr. D.K. Nath, the learned counsel appearing for the petitioner. Also heard Mr. H. Sharma, the learned additional senior government advocate appearing for respondent number 2, 2, 3, and 4, as well as Mr. R.K. Talukdar
For 5 and 6.
for respondent number 5 and 6. The brief facts of the case is, the brief fact of the petitioner's case is that a part of the building structure of the petitioner had been acquired under the National Highways Act 1956. Full stop. The building structure of the petitioner has a common wall, beam, joint, etc. with the common building which falls in right of way line, which has been considered for acquisition by the NHIDCL. Full stop. Petitioner's case is that while acquiring the portion of the building, certain portion of his building has been damaged by such acquisition. Full stop. In view of the aforesaid damage, he has submitted several representations before the concerned authorities, praying for a inspection of the site, inspection of the spot, and accordingly ascertain the damage and payment of compensation of forces damage. Full stop. It is contended that a letter dated 9/8/2021 was issued by the Deputy Commissioner Golaghat, whereby it was directed the concerned executive engineer to evaluate the partially affected building of the petitioner. Full stop. Accordingly, then another letter was issued by the ADC in bracket ADC LA Golaghat, directing the circle officer Dergaon Revenue Circle, Dergaon, to submit a detailed report after proper joint verification or stroke resurvey of the building of the petitioner. Full stop. It is a case of the petitioner that in spite of such directions were given, no such survey or inspection was carried out by the concerned authorities. And facing with the aforesaid situation, the petitioner has filed the instant petition before this court. Full stop. So all the inspection was done before, during the pendency of the case, right?
Yes, as per the order dated 9th of August 2023,
9/5.
9/8/23. 9/8/2023. 9th of August, I was my mistake.
9/8.
Yes. Second paragraph.
Okay. Yeah, during the pendency of the writ petition, full stop. While in order dated 9/8/2023, this court had directed the learned counsel appearing for the state to get the instruction as to whether the report stroke resurvey called for by the Deputy Commissioner Gulaghat had been submitted, had been carried out or not. Full stop. Full stop. After the aforesaid, subsequent to the passing of the aforesaid order by this court, an affidavit has been filed by respondent number 2 in the instant case, wherein a document dated 12/9/2023 issued by the executive engineer PW in bracket B and NH department, Jorhat District Territorial Building Division to the additional district commissioner in bracket LA Gulaghat has been annexed. It is seen from the document that a valuation report and valuation of estimated damage caused was made, which amounting to rupees 4,19,010 rupees. 10 rupees, full stop. It is seen that it is seen that a report was in fact submitted after a verification and joint inspection has been carried out in the damaged property by two junior engineers of PW in bracket B and NH department, Jorhat and Dergaon Territorial Building, Subdivision Jorhat, and Bokakhat and Khumtai Territorial Building Subdivision Bokakhat respectively. Full stop. As per the aforesaid report, the amount has been shown as rupees 4, that same amount of been shown as since.
Your lordship is relying on page 51.
Two documents are there. Page 89,
Executive engineer is also there. My lordship.
88, 89.
Page.
The report has been,
Taking up the affidavit in opposition filed by the respondent number 2.
yes,
Affidavit.
page 88. The executive engineer has forwarded only.
The sign is,
I'm relying on this document.
sign is there, man.
So he has forwarded the report stating that this is the amount.
Now, one junior engineer of Bokakhat and Kumtai Territorial Building and National Highway.
See, joint inspection was carried by two junior engineers.
And the executive engineer, it seems, my lord.
Where is that?
The valuation estimate. I don't have the serial number.
But what about page 88?
That is the letter forwarded by these two persons.
Hmm.
But the next page, my lord, estimate was prepared by 3 persons. Below, madam. The executive-
Okay, then you write forwarding the estimate by three engineers.
Okay.
3 engineers, one junior engineer, one you take it from right
One assistant
page
executive
89.
engineer and one is executive engineer.
You write the joint inspection was carried by 3 engineers. Then you write that is one is junior engineer, PWD.
PWD.
No, you can write about 3 engineers, including the executive engineer, PW BNHD, Jorhat Division, Jorhat District Territorial Division. Jorhat District Territorial Building Division, Jorhat.
Well, lordship, there again there will be difficult. This is junior engineers Bokakhat and Kumtai.
No, take it, we are not going into those details. That's not required. We're just saying that like 2 engineers along with including the 3 engineers, including the executive engineer. Executive engineer, full stop. However, it is seen from the records that though the estimate was prepared way back in 2023, the same was never forwarded to NHIDCL. NHIDCL, for whom the building structure was, for whom the land was acquired, certain land was acquired, and thereby the building structure, part of the building structure of the petitioner was damaged. Full stop. The learned counsel appearing for NHIDCL submits that they have received, that NHIDCL has received the report of the joint survey and the estimated and about the estimated amount only on 28 April 2026 from the additional district commissioner Golaghat. Full stop. In view of the aforesaid, he submits that since they were not part of any joint inspection, it would not be possible for them to release the amount without having a joint verification carried out by their own officials. Full stop. Therefore, he submits that further time should be allowed to him to verify and go for a joint inspection. Full stop. The learned counsel appearing for the parties have agreed that rather than waiting for the joint inspection, or rather than waiting for the instructions in the case from NHIDCL, a joint inspection could be carried out within a specified time, including the petitioner as well as the officials of the PW department, officials of the PW building division, as well as NHIDCL. Full stop. And thereafter, thereafter, on finding out the extent of damage, an amount can be released to the petitioner, full stop. In view of the aforesaid, this court is of the opinion that the instant matter can be disposed of with a direction to carry out a joint inspection, including the aforesaid three parties within a specified time, and thereafter release the amount for such damage. Full stop. Is there anything, Mr. Thavda?
We deposit the amount to the competent authority account.
So therefore, a joint inspection to be carried out by the parties involved. Who will notify? Who will notify first?
Kala, madam, kala.
Kala. So a joint, so therefore, a joint inspection shall be notified by Kala,
Respondent number 2.
respondent number two, and thereafter,
Three, madam, sir.
respondent number 3, and thereafter, notified within a period of 15 days. Within a period of 15 days.
Date of receipt of the certificate.
Within a period of 15 days from date of receipt of the certified copy from the petitioner by respondent number 3. Full stop. After such exercise being completed, the amount of damage shall be deposited by NHIDCL to respondent number 3. Respondent number 3. Respondent number 3 and respondent number 3 respondent number 3 in accordingly release the amount to the petitioner within a period of 3 weeks
From the date of receipt of.
from the date of receipt of, but how much time you will take to
Yes, ma'am.
deposit?
That time should be given upon the NHNCL also.
So you really, I mean, and 3 weeks time, I don't think you will require 3 weeks time to release the amount.
2 weeks will be enough, I think.
So
from our side.
I think you do one thing.
3 weeks
And
from there.
after the joint inspection, the money shall be deposited by NHIDCL to respondent number 3 within a period of 10 days. And thereafter, thereafter respondent number 3 shall release the money to the petitioner within a period of 15 days. So within 45 days, you will get it. 5 days. In terms of the aforesaid direction,
15 days, Lordship.
I don't think you'll need 15 days. NHIDCL is rich organization.
But some still profit.
A small amount. Okay, 15 days, 15 days, 15 days and 15 days. After that estimation, NHIDCL will deposit the money with respondent number 3 within 15 days, and thereafter, within 15 days, with another 15 days, the money and the compensation shall be released to the petitioner. In terms of the aforesaid direction, the instant petition is disposed of.
My lord, estimated money with relevant other things, solicium or other things, my lord, that word may be.
Whatever is that.
Yes.
Will be.
Whatever
Whatever is entitled under
Yes,
the law.
that will suffice. Oblige.
Item 9.
At least a lot. Here, I'm supposed to file reply. And not,
No further reply. You have taken many times.
I've also contacted the client, but
Hmm?
he says, my lord, to cut that sometime. I have also contacted with my client.
You have to taken sufficient times. Now, how much time you
He's
require?
not coming.
How much time you require?
Otherwise, my lord, there is a civil suit also.
So you go back there.
So on that, in terms of that, my lord, may also be closed, my lord.
Hmm?
Civil suit is there.
The land is not there, your only. How you want that demarcation?
But,
It's not passes to.
You go and fight out the case where the civil case is pending. Why you have come here? There is nothing in this case.
The account may be closed, well,
Hmm?
it may be closed.
We'll close it. You fight it out there.
Already. the
Already civil suit is filed.
respondent number have filed.
Yes.
Respondent has-
Oh, you fight it out there. And the government is also saying there is nothing on record about your ownership of any land.
They will be there.
Mr. Sharma, there's nothing on record. Hmm. Yes.
But my lord, the petitioner said to me, my lord,
Hmm?
the petitioners instructed me, my lord, that they have some documents.
See, we are going to dismiss this petition. You want to withdraw or dismiss? You tell me.
Document.
Hmm? Let them withdraw and fight it out.
With cost, Lordship, earlier they also filed a preferred petition claiming that his vendor is in possession of the land. After filing our affidavit in opposition, they withdrew it and filed the present petition with the.
Why you are doing it, Mr. Khan? I have seen this earlier also. You have filed, then you have withdrawn it.
Earlier I have filed because.
So I mean, this is but the cost will be on you.
There are some mistakes.
The cost will be on you.
I am paying since withdrawal, my lord.
Hmm? You should not file cases for just to file the cases. Only whatever your client says, you should not file. You should verify the records. Earlier also you have done this. Same thing. The land is not yours. It's a disputed land. You are claiming something. Civil suit is pending. Still you have come to the writ court.
My lord, civil suit, they have filed after filing the first case.
But second one,
Second.
why you have filed this case then? Okay, let him go this time. Third time, if he comes, then we'll put cost. Huh?
All right.
Right, we heard Mr. M.R. Khandakar, the learned counsel, appearing for the petitioner. Also heard Mr.
Yes.
Respondent number 7. Mr. H. Sharma, the learned additional senior government advocate for 326. G. Hazarika for respondent number 1. 1 and 2. Yes, Mr. Khandakar submits that he should be praised for withdrawal of the matter. Full stop. The matter is dismissed on withdrawal.
I'm the.
All right.
I'll just come back in 5 minutes.
Please, Your Lordship. My lord, yesterday we have filed the rejoinder affidavit.
Please, Your Lordship. Lordship, I am appearing on behalf of Mr. Dina. Mr. Dina, due to some personal difficulty, he could not appear today. Lordship, may kindly fix a short date as per Lordship convenience.
Lordship, we filed rejoinder.
You have filed a rejoinder.
Yesterday, Lordship.
Rejoinder to what? IA?
No, Lordship. Main case.
What is this IA for?
IA for vacation of the interim.
IA is filed by the state.
State law.
Heard Mr.
MIS.
M.I. Hussain, the learned counsel, appearing for the petitioner. Also heard Mr. D. Nath, the learned counsel, appearing for the respondent state. MS so and so.
And Paul.
I'm Paul,
behalf of Mr.
on behalf of Mr. Dina, the learned senior government advocate for the state respondent. G. Hazarika is appearing. G. Hazarika is respondent one.
Therefore, respect
MS Paul submits that Mr. Dina has certain personal difficulties today and prays for 2 weeks time. Prayer is allowed. Let the matter be listed after 2 weeks.
Interim may be continued.
Interim order so passed earlier.
Alright.
Shall continue to the next date of listing.
May your lordship, my senior is in another court. May the matter be passed for the time being.
No Passover. Have you filed anything?
Lordship, I think our affidavit will not be required if we place the case, Lordship.
Mr. Datta is appearing, yes.
Lord, we filed an application before the circle officer.
For demarcation.
No, my lord, exactly, for demarcation. Now, they did not go for, Latmandal went there, he came back saying that the other person said the civil suit is pending.
Hmm.
But civil suit is relating to partition. It's not going to affect the demarcation. Demarcation will help everybody. So that is the matter, my lord, and I don't know why they cannot go for verification and all that. This is the short point involved.
That's it, Lordship.
But is there any bar, Mr.?
Lordship,
See, if the partition is there,
if your lordship comes to page 16.
page 16,
Please, now, it's not- I'll take a thumb up. Page 14,
page 16,
Okay,
the
page
type copy
page
is 14, type copy is 14, yes.
If your lordship come to the, if we can skip the subject,
Hmm,
then next one, service name demarcation certificate,
hmm,
where there is no dispute on title.
hmm.
In that case, only demarcation can be.
So title is the different and
Yes, Lordship.
partition is different.
Yes, lordship. Now your lordship may kindly come to page 18. Has your lordship got it?
Yes.
The designation public servant, circle officer, stipulated time limit for providing the service 30 days.
Yes.
If he fails, the appellate authority is additional deputy commissioner. So without providing that opportunity, lordship, they have directly come to this honorable court. Then lordship, thereafter the designation of review authority is the district commissioner. If they are not satisfied with the action of the circle officer, they can very well place all these things before the deputy commissioner. Oh, sorry, additional deputy commissioner. Pursuant to this notification, this circular office memorandum. They can place the same thing before the additional deputy commissioner that this is not the title, this is not regarding title suit. This is regarding partition.
Demarcation.
Yes, sir, no, that.
Oh,
title suit, yes,
that suit, yes.
yes, sir. That can be done, lordship.
Yes, Mr. There is a provision.
Entire matter is governed by the Assam Right to Public Services Act 2012.
Correct.
And my lord, 4 and 5,
Hmm.
section 4 and 5 speaks like this. I'll just go through it. The state government shall.
Oh, 4 and 5.
Well, 4 and 5 of this act. Assam Right to Public Services.
But
Act.
as per the act, this notification has been
Yes,
issued.
yes,
Yes.
As per that act only.
Hmm, hmm.
Now, it speaks like this, the state government shall notify the public services rendered by it, including provision for fast track service delivery, along with user charges and stipulated time limit. Now, accordingly, my lord, we have filed the fees and all these things, and it was in time. So
Correct.
therefore,
Now they are saying that I mean,
not rejected.
as per the notification,
Yes.
the time limit is gone now.
my lord, so far that part is concerned, your lordship fix on some other date. I'll clarify that position.
No, but there is a, Mr. Datta, there is a provision of appeal, there are 2 appellate forums are there.
But I want to confirm myself. That's the reason.
But this is on record.
Let me see it once again, my lord, whether it is a mandatory or not. Just for a short time, my lord, your lordship can fix it on Monday or Tuesday.
Okay, on the prayer of Mr. S. Datta, the learned senior counsel, appearing for the petitioner, let the matter be listed on On 25th of May.
Yes.
On 25th May, Mr. H. Sharma, the learned additional senior government is present for.
2 and 3.
For respondent 2 and 3, and Mr.
Respondent number 4, A.R. Shum.
A.R. Shom for respondent number 4. G. Hazarika for respondent number 1.
Lordship, Lordship, can it be on Tuesday, your Lordship? Monday, I have some.
Okay, let the matter fix on Tuesday, 26th.
Publish.
Wait, is your lordship.
Yes.
The instructions have been called for on the last occasion. Matter pertains to transfer of prisoners from Morrigan.
Yes, yes.
Yes. We have issued an instruction, my lord. We are waiting for the instruction from the Manipur government, my lord. We have communicated with them, my lord. However, my lord, in the first list, my lord, that of Manipur has not been reflected. If they has been reflected, my lord, it will be, my lord, therefore.
Manipur is a party.
Yes, my lord.
Respondent.
Notice served.
Lordship, with respect to respondent 3, that there is a order of the Lawazima court. The IG presents, which is the respondent 4, IG presents Manipur, has addressed a communication to the court.
It has been received.
It has been received. As far as state of Manipur is concerned, Lordship, there is no response.
Okay, heard Mr. A. Atria, the learned counsel appearing for the petitioner. Also heard Mr. M. Setia, the learned government advocate, junior government advocate for respondent number.
My lord, one.
For the respondent state, respondent's state of Assam.
1, 2 and 5, my lord.
Respondent 1, 2, and 5. Full stop. Mr. Chetia submits that a communication regarding possibility of shifting the petitioners to a jail in Manipur has been communicated to the Inspector General of to the
Government of Manipur, my lord. Second page, my lord.
where is your letter?
Data has not been annexed, my lord. They have communicated. That letter has not been annexed, my lord.
Okay, submits that a communication has already been sent to the government of Manipur seeking their comments in the instant matter. He submits that the same has been done in terms of Rule 3 of Transfer of Prisoners Act 1950, read with Rule 496 of Assam Jail Manual, wherein the consent of the concerned jail, wherein the prayer for transfer has been made, is required. He submits that, however, no reply has been received. No reply has been received from the state of Manipur as yet. Therefore, he prays for some more time to complete his instructions. Full stop. 3 weeks time. 3 weeks time is allowed.
In the meantime, my lord, since my lord, government of Manipur is a party, my lord.
Yes, 3 weeks time is allowed to complete his instruction. Full stop. Registry to reflect the. Who is anybody appearing? No. But registry to reflect the name of government of Manipur in the cause list.
Lordship, may I pray for a date?
3 weeks, let them come back.
Okay.
Lordship. Lordship, my senior is in lead, Lordship. Can you pass over the time being, Lordship?
You are appearing for whom?
Respondent number 4.
Respondent number 4,
Municipal board.
Tezpur Municipal Board. Okay, we'll pass it over for time being.
Okay.
But you have not filed any reply. You have filed. Yes, Mr. Botakur. You have filed reply, na?
No, we are going to file, madam.
Hmm?
Government has filed a reply. But I am appealing for Tezpur Municipal Board, madam.
Have you filed?
No, madam. But the record revealed that the land comes under my wasteland, madam.
But it has been mutated against them. How it has been mutated? If it is a land owned by them mutated, then how it can be?
As a wasteland, madam.
Correct. I mean, but then how wasteland has been given a patta?
It's a revenue authority. Has to clarify, madam. As to why, madam, it was related to madam.
So you file an affidavit. File an affidavit.
My lord, I relinquish 1/15 lesser land.
Understand? I've seen
My
that.
lord,
You have
petition.
given that for
Yes,
drainage.
my lord, yes, my
You have
lord.
given it for drainage. Yes.
My lord.
Hmm. But I mean, patta has been given after one kotha and 15 lessa he has
Yes,
alleged.
my lord, without any compensation.
In spite of that, you are not allowing. Some other people are constructing houses there.
Yes.
And after 2 weeks, madam,
4 weeks? No. I
No,
mean,
2 weeks.
after 2 weeks. Okay. Heard, Mr.
Yes, sir. Yeah.
So I guess for the learned counsel for the petitioner, also heard Mr. S. Botakur, the learned counsel, appearing for Tezpur Municipality Board. Mr. H. Sharma, the learned additional senior government advocate for state respondents. Mr. Das is also there? No, state respondents. Mr. Botakur, you write her name. Mr. Botakur praised for 2 weeks time to file an affidavit in an instant case. Let the matter be listed after 2 weeks.
This case, the respondents are yet to file their affidavit. Despite evidence direction by this honorable court.
Mr. Nayak, you are appearing. Why are you not filing affidavit?
Repeated request, I am not receiving any communication from that department. So I am praying for at least 2 weeks time, probably this time I will make it confirm that I receive some structure.
Let him come back.
Date may be fixed, Lordship, that is my humble request. Date may be fixed, ma'am. That is my humble request.
Okay. Heard Mr. AI Ali, the learned counsel, appearing for the petitioner. Also heard Mr. P. Nayak, the learned additional advocate general for PWD department. Also,
State respondents, 2 and 3.
and that's for respondent number 2 and 3. Mr. Nayak submits that he requires 2 weeks time to complete his instruction and file his affidavit in the instant case. Full stop. Let the matter be fixed on. Fixed on. June 17th. Let the matter be fixed on 17th of June.
May please, Your Lord. Well, look, what has happened, the private respondents, well, look, from the picture your lordship will see, installed an iron gate in a public road, man. And again, it installed an iron gate in the public road, which is used by the public, my lord, as public passage.
I am appearing on behalf of respondent number 7 to 11, my lord, I pray for 3 weeks time to file an affidavit in opposition.
My lord, I have no objection in granting time to my learned friend, but having regard to, my lord, the issue in hand, my lord, what, my lord, may be developed by my learned friend. There is an order under 133 CRPC by the magistrate, my lord, pertains to year 2020, magistrate has recorded in their presence, my lord, a categorical finding that the iron gate is on a public road.
Mm.
And thereby direction has been given to them along with other respondents to, my lord,
Remove it.
remove it.
Mm.
And since then, my lord, they have not done nothing. I have approached, my lord, all the respondents from, my lord, 3 circle officer,
Mm.
GMC, GMDA, my lord, to the police officer in charge several times. Nothing has been done. Thereafter, my lord, by we have registered post.
Mr. Talutor, you have filed any affidavit?
No, Lordship, I have yet to receive. But it has to be removed by the JMC authority first, because it's on a public road. Police cannot.
No, 133 order is already there. 133 order, why are you not executing this? Who will execute this?
And my lord, my learned friend is aware, section 349 GMC Act, section 61 GMDA Act, a statutory duty is cast on them, my lord, to remove any obstruction, my lord, in a public place. And that, my lord, apart, there is an order of the magistrate also under 133. Nothing has been done, my lord. This is used by the public, my lord, as a public road. Lordship will see the, my lord, what is happening, my lord.
No, correct, but GMC or GMD also has the power. No, see, I mean, Mr. Bora, I mean, representations have been filed. You have a order from the 132 order is there. I'm not saying that you should execute it or whatever, but from your side also there is a statutory duty.
Yes. Page 46, they are party, my lord. Page 46. Lordship will kindly see, my lord, respondent, second party, respondent 7, GMDA.
Yes, which is the order? Which is the order?
Page 46, my lord.
Page 46.
Yes. Yes, last but one is the relevant portion, my lord. Second party, real number 1 5. 1 to 5 will know the private response.
Since the iron gate is erected on the government land, covered under Doc number so and so, which creates disturbances of public so and so in their peaceful movement, the second party members, serial number 1 to 5, who are 1 to 5 private respondents.
Private respondents, my lord.
1 to 5 are directed to shift the iron gate to another suitable place where it can create no disturbance so and so first party. And so we are not removing, Mr.
My lord, iron gate is, my lord,
There is a direction.
it's a private land, my lord.
There is a direction.
My lord, there the direction, my lord, I have to file affidavit, my lord, can be sometime maybe given to file affidavit. And their picture will.
No, you remove it, then you file an
My
affidavit.
lord, removal if,
No, we are directing you to remove it because there is an order.
my lord, there is an order, but. My lord,
Have you challenged this order?
No. 16/12.
Have you challenged this order, Mr.?
My lord, that order has not been, they
Then-
have challenged it, my lord. Have challenged it,
Why do you challenge it?
my lord.
A direction has been given to you also to remove it.
Lord,
Have you challenged this?
that order has not been challenged, but my lord.
Then
can
if you
see
have
the-
not challenged this order, then remove the iron gate.
Kindly see them.
You remove the iron gate immediately.
Iron gate, my lord, it is 133 proceedings, my lord. There should be a specific direction. My lord, 135, section 135, CRPC. There is no clear cut, my lord, direction to the respondent numbers 11 to 7 to 11, my lord, 7 to 11. And that should be a final order, my lord. My lord, I have to, my lord, chance be given to.
No, I mean, do you want to say that the magistrate order directing you to remove something after hearing the parties, do you think that, I mean, that order you should not comply with?
My lord, that order, my lord, kindly see that order, bag number, patna number.
Hmm.
I will clear, my lord. If there is a dispute, my lord.
Hmm.
I
No,
will
then
let-
you should have challenged this, mister.
My lord, I
Then
will-
you should have challenged this order. Then I do not comply with this order.
There to implement it, a specific order should be there before.
What specific
by the-
order?
By
What
the
specific order?
executive magistrate.
Who are you? Who are you?
I
Your
am-
name is
I
what?
am-
What is your name?
My lord, my name is, my lord, 7.
Hmm?
Respondent number 7 to 8, my lord.
Are you Tulu Prabhadas?
Yes, yes. Correct.
Atul Chandra Das,
Yes, yes, my lord.
Deepak Chandra Das, Malloy Das.
Yes.
Then,
Yeah.
this order is given to, order is given to, serial number 125 are directed to shift the iron gate.
1, 2, 3, my lord.
Serial number 125 in page 46 have been directed to remove the iron gate.
My lord, if there is a blockade, my lord,
And don't give all this kind of if that if and dot, if there is a blockade, non-blockade. There is an order of the of an authority,
get an
and
opportunity.
you have not challenged that order.
My lord, under section.
You remove this, then you file an affidavit.
My lord, section.
No. You
35.
remove this, then you file an
Okay, fine, my
affidavit.
lord, kindly see, which is not, if it is final order, my lord, that is another issue.
Not final order. There is an order. Well, there is nothing like final order, interim order, or whatever in this case.
My lord, say under CRPC 133 proceedings,
Show me what is the proceeding.
my lord, today I am going to, because.
No. We are not.
For the
We are.
first time-
No, you give him that CRPC.
For the first time, I am.
Give him the
appearing
CRPC.
Today.
the
So,
CRPC.
my lord, sometime maybe given to, gone through the petition.
You cannot sit tight and like non-complying with certain statutory orders.
Sometime, because I, for the first time of today, I am appearing, my lord. Sometime maybe, they have spent so many times, my lord.
See, we are fixing it.
Sometime maybe given.
We are fixing it on Monday. Monday, if you do not come up with proper things,
My lord.
proper instructions, then we will direct to remove this iron gate immediately.
Sometime
And
maybe.
Monday will be fixing it. Monday or Tuesday.
Tuesday.
Okay, I heard Mr. S.K. Talukdar, the learned counsel appealing for the petitioners. Also heard Mr. B.J. Talukdar, the learned additional senior government advocate for you are appearing for whom, Mr. Talukdar?
This one number.
1, 2, 3. 1, 2, and 3.
1, 2, and 3, Mr.
Not 1, 3 and 6.
3 and 6, Mr. P.K. Day for
7 to 11.
7 to 11. Mr. S. Bora, the learned standing counsel for GMDA for 4 and 5. MSP Mohanta for 1 and 2. 1 and 2. Mr. Day submits that he has appeared in the matter for the first time and he requires some time to get proper instructions in the matter. Let the matter be fixed on Tuesday, that is on 26th. On that date, Mr. Day will intimate, Mr. Day will file his affidavit in opposition in the matter. That should be the spirit, Mr. Day. We appreciate your spirit that you are saying that affidavit will
Before
file.
Tuesday, you should file. Then they will.
At least he is saying that he will be filing affidavit.
It's for cancellation of GST registration.
Have you filed any affidavit? Why?
We haven't received any instruction regarding that.
But you can go on saying that you have not received any instructions.
Otherwise,
You have cancelled his GST certificate.
Otherwise, my lord, the similar matters are already been taken up by before. One thing is that, my lord, at page 28, the so-called notice is there, wherein at page 28 is the so-called notice,
28.
man, annexure 2.
Yes.
The reason for the SOCOS, my lord, serial number 1, any taxpayer other than composition taxpayer has not filed returns for a continuous period of 6 months, my lord. Subsequently, my lord, at page 29 is the impugn order. My lord, it says next page, my lord, 29. That is the impugn order of cancellation, my lord. It says, my lord.
Why didn't you pay?
No, my lord, that was, my lord, I am engaged in this tours and travel. So during that COVID period, because my lord, the business was down. Subsequently, we came to learn, and this SOCOS notice and all were been uploaded online. That was not duly communicated to us. And unfortunately, my lord, at page 29, it says, my lord, they have received their reply dated 16/9/22. But my stand is, my lord, at no point of time any reply has been filed by me.
Okay, we'll dispose it off. Your name?
H.K. Sharma.
Heard Mr. H.K. Sharma, the learned counsel for the petitioners. Also heard Mr.
KJ on behalf of
K. Jain on behalf of Mr.
SCK
S.C. Kayal, the learned standing counsel, CGST. Standing
for 2
counsel.
and 3 lots.
CGST. Respond number 2 and 3. 2 and 3, full stop. The petitioner has approached this court aggrieved by the cancellation of its registration under CGST Act 2017 by an order dated 29/2022. The petitioner's case is that petitioner is engaged in miscellaneous trade registered under the provisions of Central Goods and Services Tax Act 2017, bearing registration number 18 AA, capital A, all capital A, D, F, H, 3326 D, 5 Z, 0. Being the registration certificate issued on 28/6/2022. The petitioner has been carrying out his business under the name and style, in quotation, Holiday Air Travels, quotation complete, a partnership concern of which the petitioner is the managing partner, having its registered office at 80 Road, Sipsagar, full stop. It is contended that because of non-filing of GST returns for a continuous period of 6 months, the petitioner was served with a SOCOS notice bearing reference number Z, all capital Z A 18092202029Q dated 3/9/2022 by the superintendent, whereby the petitioner was asked to furnish a reply to the aforesaid SOCOS notice within a period of 7 days of service of the notice. And from then don't write and from the same date, the GST registration of the petitioner was suspended. Full stop. Why didn't you file the reply?
Madam, that was uploaded in online and I was.
But
not-
so cause notice was not physically given to you?
No, no.
Okay. The petitioner contended that pursuant to the aforesaid so cause notice, which was uploaded in which portal?
The GST portal. Madam.
Uploaded in the GST portal. Since the time period of 7 days was already over when the petitioner came to know about the so cause notice, the petitioner could not submit its reply to the aforesaid so cause notice, correct? So cause notice, full stop. It is the case of the petitioner that the petitioner, due to heavy loss during the COVID-19 pandemic, could not file, was unable to submit his returns in time and thereby defaulted in paying for the aforesaid period. Paying the GST returns for the aforesaid period, full stop. The learned counsel appearing for the petitioner submits that he is a small-time businessman, and due to the sufferings, due to the economic loss and sufferings during the period of COVID-19, he could not file the returns in time. However, the same is not intentional. He further submits that in similar situations, this court has directed the GST authorities to restore the GST registration of the defaulters, full stop. In this connection, he has referred to the case of Nuruddin Ahmed Pathan versus State of Assam and others, in bracket WPC number 2575/2025. Decided on 30/5/2025. Full stop. In the instant case, no affidavit has been filed by the GST authorities as yet. Full stop. It may be relevant at this point of time to refer to certain sections, certain provisions of CGST Act 2017. Section 39(1) of CGST Act 2017 inter alia requires a registered vendor to furnish his returns for every calendar month or part thereof, electronically, of inward and outward supplies of goods or services, or both, input tax credit availed, tax payable, tax paid, and such other particulars, in such form and manner, and within such time, as may be prescribed. Section 29(2)(c) empowers an officer, comma, duly empowered, comma, to cancel the GST registration of a person from such date, comma, including any retrospective date as he deems fit, comma, where any registered person or vendor has not furnished returns for a continuous period of 6 months. Full stop. Rule 22 of the CGST rules, comma, 2017 has laid down the procedure for cancellation of the registration. The same being relevant, Rule 22 is extracted herein below. You can take it from page 32, page 32 of the repetition. A reading of the aforesaid provisions under Rule 22, comma, especially sub-rule 4, it is seen that if a person who has been served with a so-called notice under section 29 in bracket 2C of the CGST Act, comma, 2017 is ready and willing to furnish all pending returns and to make full payment of the tax itself, along with the applicable interest and late fee, comma, the officer, comma, duly empowered, comma, can drop the proceedings and pass an order in prescribed form, that is form GST capital REG-20. Taking into account of the fact that GST registration of the petitioner has been cancelled for the reason that petitioner did not submit his returns for a continuous period of 6 months, comma, the provisions contained in proviso to sub-rule 4 of Rule 22 of CGST Rules 2017 and cancellation of registration entails serious civil consequences, comma, taking into account the aforesaid case of Nuruddin Ahmed Pathan Supra, this court is of the considered view that in the event the petitioner approaches the officer, comma, duly empowered, comma, by furnishing all pending returns and make full payment of such tax dues, comma, along with the applicable interest and late fees, comma, the officer duly empowered, comma, has the authority and jurisdiction to drop the proceedings and pass an order in the prescribed form. Therefore, in the considered view of this court, this instant writ petition can be disposed of by providing that the petitioner shall, by directing that the petitioner shall approach the concerned authority within a period of 2 months from passing of the instant order, seeking restoration of his GST registration by filing a proper application. Full stop. If the petitioner submits such an application and complies with all the requirements provided in the proviso to sub-rule 4 of Rule 22 of the CGST Rules, 2017, the concerned CGST authorities, so concerned GST authorities. GST, right, is
CGST.
CGST, concerned CGST authority shall consider such application of the petitioner for restoration of his GST registration in accordance with law and shall take the necessary steps for restoration of the GST registration of the petitioner within a period of how much? 15 days. Within a period of 15 days after receipt of such application. Full stop. In view of the aforesaid directions, the instant petition is disposed of.
Much okay.
Item 19 and 20.
I am in to my 20, my lord. My lord, if I is in 19.
My lord. Some, have hold on, my lord, separate case have been filed, my lord. I have
Two set of shareholders, my lord, 2 cases on file.
2 more cases have been filed.
No, these two.
two cases.
19, 20.
Okay, these 2 cases.
Two cases.
Ah.
Similar.
Yeah, here what happened, this is the case of Kurwa Samvaya Samiti, my lord, in North Bank of Gauhati, falling within Darang district.
I mean, yeah, you all are not filing any replies to the affidavits?
No, because they have admitted, my lord. Very, in paragraph
Okay.
5, 6 and 7 of the registers, very well, kindly see.
You are appearing in item number 19,
I am being 20.
20.
Division 19.
So Rudramani Bora
Yes,
and others.
Doesn't Bora, my case. The register has admitted, my lord, in paragraph 5, 6 and 7, that
Hmm?
there was anomalies in preparation of the voter list, and non-members and non-shareholders and voters who were defaulter in payment of the dues to the society were also allowed to participate. But total membership shareholders in the society is 1820. So 10% of the total member or shareholders is the quorum.
Yeah, kindly give me some details about the facts.
Yes, ma'am.
Some details about the
Yes.
facts.
My lord,
Is a Samavaya Samiti, correct?
Samvaya Samiti,
Mm.
under the Cooperative Societies Act.
Mm.
But whatever, my lord, this is the case of Kurwa Samvaya Samiti, Kurwa Cooperative Society. In 2024, the annual general meeting, there is a lordship knows, my lord, that voter list is prepared in advance, circulated, well circulated, and then my lord, election is held. And the requirement is, my lord, at least 10% of the total shareholders out 182 out of 1820 are to be present
Present, yes.
to fulfill the quorum. Here what happened? About 93 members, non-members, defaulters, and debtors.
Was there any difference between members and shareholders?
Well, shareholders,
All members are shareholders?
it is same.
Is it so? All members are shareholders?
Members are all general. Even the entire village may be.
Correct. I mean, that's why I'm asking.
But shareholders are those who purchase share of the society.
Shares there, yes.
Yes.
So the quorum is what? Quorum is shareholder or members?
Shareholder.
Shareholders. Okay. So you are saying that some of the members, that means they may not be shareholders.
Yes,
They have voted.
they have voted.
Hmm.
Because
But their names were there in the voter list?
no, the voter list, the chairman, what he played, my lord, he illegally made a voter list of his own and allowed them to participate because chairman controls. Then we filed a complaint. They also filed the other item 19 also we also filed.
You all were shareholders.
Yes.
Hmm.
That's why we are here. Otherwise we don't have any right. It is the AGM, not general meeting. Then, my lord, we filed a complaint before the assistant registrar for
The election was held.
Yeah.
Then somebody was already this thing elected.
Election
The
elected.
body is elected
Yes.
and president, vice president elected.
Yes, yes, everything.
Hmm.
Then against that voter list and the illegal election, we filed a complaint, my lord.
A private parties who are appearing, you are appearing for somebody. Secretary.
Then, my lord, what happened? After the complaint was sent, secretary was asked to
Hmm.
make an inquiry. He made thorough inquiry and found that yes, there is serious anomalies and it doesn't stand. Then, my lord, corporate society, ARCS also
Hmm.
made an inquiry. He
Hmm.
also found that anomalies there.
Hmm.
So he refused to approve the
Hmm.
body. Against that, the other side, the private respondent went to it is a register. What he did, he turned the table down.
Hmm.
And
He said that there is no anomalies.
yes,
Hmm.
then we filed an appeal before the registrar.
Hmm.
Registrar also upheld that. Then we come to High Court. High Court again was the registrar order, which was against us.
So this is the second round litigation award.
Yes.
Hmm.
Then remanded the matter to the registrar matter to look into a fresh and fastness order.
Hmm.
Again, he had the same thing.
Hmm.
Then against that we are here.
Okay. Okay.
So there is that. And now let us kindly come to the affidavit filed by the registrar.
Yes.
The private respondent separate appeal.
You are who? Chairman of the society.
You are in 19.
You are no, he's not made a party or what?
No, they are subsequent, they are not party.
Huh?
Oh.
I mean, this petition I didn't find. That's why I was asking who is appearing for the private parties. But here only five respondents are there. In your matter,
Yeah.
5 respondents
No,
are there.
later on we made the party.
Where is
There is no mistake.
is there any amended petition? First title?
Yes.
And there is nothing on record. No, item number 20, there is no private parties.
Yes, my lord. We filed an application, my lord, it is an application for implement of necessary party in the resolution of so.
Where? Win Cave's case.
I think there is separate IAM, my lord, there was we have added.
There is no order.
We have added, my lord, Purva Samaya Sambati and Mainul Haq chairman.
Is there any other record? This is in India. I can do all of it. No, this was all trouble. Any cost at
IAM number, my lord, 311-2025.
This was dismissed on withdrawal. Three one 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 in 4919. 4911. This I was withdrawn.
That was done, my lord. See, my lord, there is a party, my lord, party, that's why my lord secretary is saying.
Huh?
Item number 19, my lord.
Ah.
I was filed.
No, I'm talking about your matter. You tell me about your matter. Your matter is item number 20.
20, mine matter is 20.
Item number 20.
I am on 19.
I'm not talking about you. I'm talking about him.
So here what
Item number 20. There is no. You have not made him party.
application file, my lord, it was withdrawn on the ground that, my lord, because secretary of the society was party earlier. Yes, that's why
Because executive authority is secretary.
No, I mean, you are raising an issue
Yes.
about the election of the private party also. He is the elected person. But without him, how can you file this?
Because secretary is my party.
The secretary is a government appointed person. I mean, cooperative society appoints it, right? Secretary.
So he represents the cooperative society. That's why it was because.
But the person who is elected, but in the other item number 22, he has been made party. They filed an IA for implement of another person, secretary, who the one IA was filed that was withdrawn by you. That was withdrawn because you have already made him a party. Him a party. But in your case, nobody has been made a party. But without party, how it can go?
3 people want. So that I'm on.
3 people want, Mrs. Sharma, you filed an IA.
Yes.
IA, then subsequently it has been withdrawn. You wanted to make him a party. 2 parties you wanted to add.
Yes.
6 and 7. Kurva Samavai Samiti by chairman and Moinul Haq, the chairman of Kurva Samavai Samiti Limited. But it has been subsequently withdrawn.
Hey, but now I realize there is a mismatch. Mismatch. Mess. Whatever, because 2 cases come together. So he would do. With him, I also got.
That cannot be. I mean, that cannot be. I mean, without him, how can this matter can be heard? He has to be a party in this case. He is an interested person. He has to say certain things because he is an elected member.
Yes.
You file an IA. You file an fresh IA.
Same I will repeat it. Anyway.
I don't know why it has been withdrawn.
I think he will do that. Whenever that is also why. That's how it happened.
Let them file an IA because he has to be a party.
Correct.
Without him, how can it be heard? He's an elected member, whatever. I mean, you are challenging the election process, but he is an elected member, whatever way.
But in one case, he has appeared. 19.
One case he's appeared, it's a different thing. But in your case, like if you want some relief, then how the relief can be granted without hearing him? You'll have to file an IA. Heard Mr. R.P. Sarma, the senior counsel, appearing for the petitioner, assisted by so-and-so. Also heard Mr. S.K. Talukdar, the learned counsel, learned standing counsel, co-person department, Mr. M.I. Hussain for
Response number 6 in item number 19.
that's one number 6.
And response number 5 in item number 20.
2 items are there. Then you write first about this item number 20. In 20 you write. Mr. 20 you write about 20. What is that? Response number 5. In this matter you write Mr. R.P. Sarma prays for some time to file an IA to implead the president, chairman. Implead the chairman elected by filing an already written, no? Filing an announcement. He prays for 2 weeks time for that.
1 week.
Okay, he prays for 1 week time for the same. The prayer is allowed, full stop. In the other matter, you just make their this thing and let the matter be listed after 2 weeks. 2 weeks. And other matter just only show their presence, show their presence and along with this matter.
19 matter.
19
If there is a my lord of chairman is already party, that's why my IA was withdrawn.
Along with that, it was.
No, I understood that. Your case is fine. Your case is already a party.
Already party.
So that's why you have withdrawn that. Because you wanted to implement two persons, but already chairman is there.
Oh, yes.
So that's not required. Your petition is fine. Your application is fine.
My
In the
lord,
other matter, take his, record his name,
Yes.
presence, and other parties. And both the matters will be heard together.
my lord, a date may be given.
After 2 weeks, let him file this. IA has to be allowed first, then only matter can be done.
Item number 99, and very well. And since the issue is same, I believe the same will suffice.
That can be done. That can be done. Yes.
Your Lordship, petitioner is aggrieved by the order of cancellation of the fair price shop license, Lordship.
Hmm.
Lordship, so-called notice issued,
Hmm.
and that is based on the inquiry report. Lordship will find the so-called notice at page 47. The first paragraph,
Yes.
whereas may I read, Lordship?
Hmm.
Whereas an inquiry was instituted against the alleged malpractices of PMGKY rise for the month of July, August, September 2020. Actually, it should be July and August. And Shri so and so was instructed to inquire into the matter by the order dated month. The matter was duly inquired by the ADC and submitted her inquiry report on 3/12/2022. Now, my specific case is that although this so-called notice was served, here they have not enclosed any documents as well as the inquiry report. And based on the inquiry report, the cancellation order was issued.
Now, where is your reply to this?
Reply, Lordship, I will file an additional affidavit.
Hmm.
Additional affidavit, I bring that reply.
Hmm.
Lordship will find at page 123. Additional affidavit. Lordship, kindly come to the vernacular language of the submission made by the
123.
123. It's the additional affidavit starts from page 123.
Hmm?
The additional affidavit
Hmm.
filed with the petitioner, it will start from page 123. And the so-called reply, Lordship will find at page 132. On 15/3/2023.
Hmm.
This is vernacular language, may I read, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে জানিব আপোনাৰ চিঠি নং ইমান মৰ্মে মোৰ বিৰুদ্ধে অনা অভিযোগসমূহ মই অতি সবিনয় অস্বীকাৰ কৰিছোঁ। মহোদয়, মই কোনো মাহতে সুলভ মূল্যৰ চাউল প্ৰত্যেক গ্ৰাহকক নিদিয়াকৈ খোলা বজাৰত বিক্ৰী কৰা নাই। মহোদয়ক অনুৰোধ জনালোঁ যাতে মোৰ দোকানৰ অধীনত থকা সকলো ৰেচন কাৰ্ড পৰীক্ষা কৰে তেতিয়া সকলো গ্ৰাহকক প্ৰতি মাহে সঠিক হিচাপত চাউল বিতৰণ কৰাৰ কথা প্ৰমাণ পাব। মহোদয়ক অনুৰোধ জনাও যে অতিৰিক্ত উপায়ুক্ত মহোদয়া বাইদেৱে বিচৰা ধৰণে বহিপত্ৰ দেখুৱাব নোৱাৰাৰ বাবে ক্ষমা বিচাৰিছো।
That means when the inquiry was done, I mean, these things were sought from you.
Yes, Lordship.
So you are admitting that that an inquiry was done and you could not produce certain
The
documents.
reason I have stated, Lordship, in my reply,
Hmm.
that for those 2 months,
Hmm.
July 2022 and August 22, we have distributed rice, Lordship, by maintaining the biometrics, that is by EPOS machine, electronic point of scale.
But are you not required to maintain, I mean, this stock book
For-
and everything?
It's required, Lordship, but for those 2 months, Lordship, I have not maintained the register.
Then it's it's your fault.
Because at that time, Lordship, the Aadhaar link was not, Lordship, completed.
Those things, whether you have stated all these things in your reply, no?
Yes, yes, yes.
No, in your reply, why haven't you stated so?
Now, while Lordship, I have, Lordship, submitted the statutory appeal. In statutory appeal, Lordship,
Yeah, where is the statutory appeal?
Lordship, after this, Lordship, or so-called, Lordship.
After this so-cause you have replied, then
No, then that, Lordship, the cancellation order issued.
cancellation was already issued.
22/1/2024.
Where is that?
That page, Lordship, you find at page 51. Empty, Lordship, based on the inquiry report, matter was duly inquired into by ADC with assistance from executive magistrate, food and civil supply inspector, and submitted her inquiry report to the undersigned. So within the.
No, one second.
Lordship,
51, okay.
page 51. This was issued on 22/1/2024.
Your name is Muhammad Ali.
Muhammad Ali, Lordship.
So,
The term and condition of the license is, Lordship, violated by not maintaining the register for these 2 months, July and August 2020.
Hmm.
And for those 2 months, Lordship, we have distributed rice, specifically I mentioned, by maintaining the biometrics.
no, that is not the statutory the requirement.
At that relevant point of time, since there's a Aadhaar link was also pending, so we could not maintain the register, Lordship. Then immediately filed the appeal.
No, what is the connection between Aadhaar and this thing? Aadhaar link and the register?
Because as they
What is the relevancy of Aadhaar card and this register?
Because they have it was, we had some mistake, right? Lord, I would take instruction, Lordship, but I have submitted here.
What is this document 52?
52. Oh, initially, Lordship, what happened, Lordship, I filed this writ petition, Lordship, in respect of 4 number of petitioner, then I filed amendment petition, Lordship. Now this writ petition only mean for this Muhammad Ali. So at that relevant point of time, the annex these documents for those petitioner also. Now they are named now deleted.
Hmm.
Now thereafter I filed the appeal, statutory appeal,
Yes, statutory appeal, what happened where?
page 61, annex 9. This was filed on 26th of February 2024.
Mhm.
I specifically took that plea, Lordship, that inquiry report was not furnished.
Now, where is the explanation about Aadhaar card or whatever? The inquiry report, you forget, you have been given opportunity. You have been given an opportunity to submit your documents.
No. Because
You yourself admitted that you could not submit those, I mean, what was that? Stock register.
in paragraph 2, Lordship, that the appellant 63 page paragraph 2, Lordship, the appellant expressed that after getting the license, he used to leave rice under so-and-so scheme for the recognized consumers of the village so-and-so and distribute the same among the beneficiaries. The appellant collected rice after making necessary entry in the lifting register.
Where is that?
That lifting register is within the Lordship, the secretary of the Samavaya Committee. It is not with me, Lordship. The distribution of rice has been done through EPOS machine. At the same time, entry has been done in the respective ration card of the consumer. And this is admitted while I obtained the RTI reply for last two months. Let's say if we come to the reply of the RTI, they have submitted these papers. In my fair price shop, there are 120 number of card holders. Now, out of 120 numbers of card holder, 110 number of lordship beneficiaries avail the benefit. That lordship, from their report, it is reflected.
Availing benefit is not the question here.
Only lordship 10 numbers of card holder in my.
No, but whether this availing benefit is only the issue.
Yes, also because their specific cases they have diverted the rice. My specific case is that for those 2 months lordship, by maintaining the biometric, we have distributed rice, and that is also reflected from the RTI report. Because in my shop lordship, there are 120 number of lordship beneficiary. Now, out of 120 lordship, 110 number of beneficiary already avail the benefit. So where is the question of lordship selling this particular in the black market? That lordship will come to the RTI reply.
Where?
RTI reply. The page 78. It is their reply. The application as sought by the application 80/2024 under RTI is given below. In fact, lordship, by RTI application of this 80/2024, before issuing the appellate authorities order lordship, I have lordship sought for that inquiry report. Now, regarding those 2 queries, they have replied like this.
Inquiry report, inquiry report, okay, inquiry report, we'll look into it, but
Yes.
like now should be for RTI, what is that?
Yes, the report of distribution, PMGK and NFSA rice for the month of July, August is enclosed here. So lordship may kindly come to page number now. Next page. My name is at the first lordship, short lordship. From bottom, second one, Muhammad Ali. Muhammad Ali lordship, see total cards 120.
Muhammad Ali.
Muhammad Ali, MD Ali lordship.
Total card does 179.
No, 120 lordship. Muhammad Ali again.
Page 79. Right?
Page 79.
Page 79, you're saying they're like number 2 from the bottom. Muhammad Ali.
Name is Muhammad Ali.
So total cards 179. Where is 120 you're saying?
It's 120 lordship. First table.
Huh?
First table lordship.
That's a first table. This is August, okay. In July, I mean, concerned months are
Then July, yes, July and August.
July and August.
For July lordship 179.
No, for August 179 and avail 147.
147.
And in June 120 and 110.
10.
The concerned, I mean, the months in dispute are
July and August.
July and August.
Lordship.
July and August. So July is 179, 134.
134.
So 120 is irrelevant.
Yes, lordship.
120 that doesn't have any.
We are concerned here with July and August.
July and August. So 179, you are giving 134.
134.
And 179, you are giving 147.
Because at the concerned month lordship, all the consumers are not coming at the.
No, correct. So that is why I'm asking you. I mean, this may not be relevant.
Oh, it is relevant because.
If some people are not coming, since you cannot force somebody to come and I mean take it, but you'll have to maintain the register.
Yes.
That in particular month, this much people came and this much people have availed it. And in this month, this much people came and this much people have availed it. And these were the remaining the materials. So where is that register?
Now, lordship, kindly see, by maintaining the same procedure in Maregaon district, there are 49 numbers of lordship or fair price shop as a lordship. Against them also same inquiry is conducted, and the inquiry officer submitted the report. Yes, they have also lordship distributed the rice through EPOS machine. I have brought those documents in the additional affidavit.
No, see, the allegation is against you, right? Allegation is against you.
Allegation, there are altogether 49 number of agents lordship.
Okay.
So that is why inquiry was conducted, page 140.
Inquiry was conducted against 20 people.
This lordship, left out 24.
How many people, inquiry was against how many people?
Initially, in respect of our 19, and this is additionally 24. 24 plus 19.
So
is almost
43.
43.
43.
Yes.
So 43 people inquiry was conducted against 43 people.
Again, 43.
And what happened to all those people?
Lordship, see the same report. Now they have accepted this report.
Which one?
Lordship, page 140. Type copy, Lordship, Annex 70. May I read from the very beginning, Lordship?
140.
140 of the additional appeals. And this also I have obtained through the RTI reply, Lordship, RTI application. Here, Lordship, they have accepted, except me, Lordship. The same procedure also they follow.
Let us see what is that.
Yes. I'm reading from this with reference to the complaint cited above forwarded by the Superintendent of Police CM Special Vigilance Cell. File letter so and so as per your order dated 113 I City Rupam so and so inspector along with so and so Morigaon visited 25 numbers of papers of dealer under so and so to investigate the alleged discrepancy in the distribution of PMGK rice for the month of July, August, September. During inquiry through review of sale register, stock register, lifting book, and other documents were completed. No discrepancies were observed during our review. Further, it was observed that stock and price display board of the aforesaid FP agents displayed.
Whether this 24 includes you?
No.
Then?
No, what I am trying to submit, Lordship, like me, for those two
No,
months.
yeah, see,
They-
you are only taking, see, here there is a clear cut conclusion that no discrepancy was observed during our review for 24. But there was a discrepancy found in your case.
No, what I'm trying to say, Lordship, for me, Lordship, these 2 July and August, I have not maintained the register.
So that is the problem.
And this similarly, the left out or the other fair price of agent also, which is revealed from this inquiry.
Yeah, from that inquiry, they found that there was no discrepancy, but in your case, they found discrepancies.
They have also Lordship distributed the right, they have admitted what.
They may have, but like they may have got registers also. How do you know they didn't have
No,
registers?
Lordship, the further a statement of last line, a statement from each of the fair price of agents were received, wherein they have stated that they had distributed the PMGK rice for the month July, August, September.
One second. Well, further it was observed that stock and display price board of the aforesaid of agents were displayed near the entrance as per so and so.
Lordship.
It was observed. That means there is they have seen that. We also interact with the beneficiaries of 24 numbers of shops.
So,
Every shop agents on a random basis, and I've already received full quota of so and so, so and so, so and so. We have taken statements of 10 beneficiaries and 24 numbers of shops. And so and so. We also collected photocopy of the restaurant cards and so and so. Further statement of each other shops were received, wherein they have stated that they have distributed
yes,
so and so, so and so.
the
The benefits as per allotment partly
through EPOS device,
Ah.
online and partly through offline, as the most of the other feeding of the beneficiaries were still pending during that period.
Correct.
Other feeding of beneficiaries are still pending during that period. So, like this Lordship fair price of agent Lordship.
See,
I
there
also
was an inquiry against these 24 people.
Now, if we go by the inquiry report against me, they have randomly, if Lordship kindly come to the inquiry findings against me, Lordship. Because they have not properly conducted this inquiry, that Lordship find the inquiry report against me. Page number 35. Page number 35. They have randomly collected Lordship 2-3 cards, Lordship, and the finding will be kindly see. Page number 35. The origin one. This is the inquiry report. And we have recorded the result for also. May I read this finding against me? In our field visit, Lordship got it, page 35.
Yes.
In our field visit dated 10/11/12, we have randomly, they have admitted the Lordship.
No, there also they have done randomly.
Collected the data for some of the beneficiaries, whether the beneficiary got their entitlement or not under PMGK rice for the month July, August, September. And from the collected data, it is revealed that out of 2 sample, 2 numbers of beneficiary, all 2 beneficiary have got their entitlement of rice for the month of July, August, September under PMGK In all three ration cards recorded data found in ration card, out of the 3 ration cards are found in the custody of the consumer. This is happening for me. In the hearing 22, the fair price shop dealer have not able to produce the valid document regarding the sale and stock register of essential commodities. So this is the violation.
What is the violation?
So this is violation why I have stated that because we have distributed the rights to maintaining biometric or maintaining the EPOS machine.
No, but like, no, that cannot be a ground. In the hearing so and so,
Now, in the hearing
FPSD
dated so and so,
have not been able to
they-
produce the valid documents regarding sale and stock
You-
essential commodities.
for these 2 months, July and August.
What happened to these other people? Iman Ali, Malida Khatun, all these people, the same thing happened.
So far, though.
Is there any arbitrariness in your case?
Yes, Lordship, because that 20, against the 24 out of 43, 24 has been scot free, Lordship. They are saying that the.
No, what about these people? In this inquiry report,
In respect of along with this petitioner, Lordship, there are 6 more petitioners, their license also cancelled. That is before your Lordship, Lord. But other Lordship, I have no knowledge, Lordship, what happened against them, Lordship.
no, whoever is not having this stock register,
Lordship.
the same thing happened to them. It is not your case that you have been something has been arbitrarily done, only you have been singled out.
Out of the 43 Lordship, the 20.
43, 20, 23, they must have got.
Because they also, the discrimination, they also distributed rice by maintaining the EPOS machine. They have also not produced that sale register. Here, in my case, Lordship, their allegation is that for this.
In those cases, they have verified with the customers also.
Yes,
Correct.
in my
In
case
your
also,
case also, it has been verified about two people they have verified.
Verified. It's
And
from-
and only thing was that like your stock register was not there.
Yeah, Lordship.
Correct. And as far as the other people are concerned, who have been given a this thing, where is that?
That 24 and 24. Against 24, Agent Lordship.
That your additional affidavit.
Oh, yes. Page 140, Lordship. Their finding is that therefore, from the above inquiry and review received from the investigation, it cannot be concluded that no malpractice were committed in the distribution of PMGK during the month of July, August, September. I am relying on decision of this honorable court, Lordship. The coordinated bench of this honorable court held that if the inquiry report is not submitted, then Lordship, there is a violation of national justice, Lordship. Because based on that inquiry report, the final decision has been taken. Relying on some apex court decision also, this finding has been given.
Where in the fair price of inquiry?
Yes, yes.
Show me that where is it?
Paragraph 11, Lordship. Paragraph 12. Paragraph 12. A specific query was made. Specific query was made. bear it, Lordship. So also the personal commissioner. Furnished with seeking his explanation in the finding arrived in said report. At the paragraph 10 also, Lordship.
One second.
Lordship.
Yes. Let us see the impugn order again.
Yes.
It is a page.
The page lordship. 51.
Yes.
May I read this?
Yes.
Whereas 22/1/2024. Whereas an email was received from the Additional Director General of Police, Government of Assam, Sri so on 2/11/22 alleging large scale malpractice in the lifting and distribution of NFSA rice and PMGK rice by the Secretary of so in collusion with the FP shop dealers attached to the GPSS. Whereas public complaints were also received against the same GPSS FP shop dealers under it alleging the same malpractices. Whereas a magisterial inquiry against the malpractice was ordered by the undersigned headed by so Additional Deputy Commissioner and Additional District Magistrate Morigaon, assisted by so the Executive Magistrate and Circle Officer Laurigat, Sri Srimati so both then Inspector of Food, Civil Supplies and Consumer Affairs, Morigaon, and Sri Sub-Inspector of Food, Civil Supply and Consumer Affairs, and the file order dated 7/11/2022. Now, whereas the matter was duly inquired into by the ADC with assistance from the Executive Magistrate and FCS and CA officers, as stated above, Morigaon, and submitted her inquiry report to the undersigned 3/12/2022. Whereas the inquiry report revealed that Muhammad Ali, a piece of dealer under so has diverted.
Mr. Thetia, inquiry report not given?
Yes, my lord, inquiry report not given, my lord. In fact, my lord, he submitted the supposed reply on 15/15/2023. He filed an IPI application for inquiry report on, my lord, 8/2020, after passing of the cancellation order.
And the inquiry report, he is not required to ask for, you are supposed to give him.
My lord,
Because
at
you
the
are basing this cancellation order on the basis of the inquiry report.
Yes, my lord, that is true, my lord.
The inquiry report has not been given.
In fact, my lord, he should have, my lord, thought for the inquiry report at the time of filing of the supposed reply, my lord. At the time of filing the supposed reply, he should have thought for the inquiry report, my lord.
No,
He
no,
has not
inquiry
thought for-
report you were supposed to give him, you have committed, you have done an inquiry, so he has the right to get the inquiry report.
Yes, sir. My lord, inquiry report was punished or not, my lord, I have still speaking.
No, Kia, what instruction? You have not given anything to him.
No, it's okay. The documents, it is not shown that, my lord. But it was punished, my lord. So-called notice. So-called notice, it is not unless notice. In the supposed notice is not available. That is to my lord.
And there is a judgment from the coordinate bench saying that if inquiry report is not given, then this is a case of the fair price shop only. All these people like concerned officers, they must be aware of this judgment and order. In spite of this, focus notice was, inquiry report was not given. We'll have to allow this. No, I mean,
I will let him we'll find him supposed inquiry for my lord, and he can reply after that. my lord.
this, So now this case is only for petitioner number 1.
One lordship, there are other 6 other things also. I have separately filed the rest 24, 25, 26 item.
Hmm?
Item number 25.
The other number items
The
also.
same order, item number 24, 25, 26, 57 and 58.
So all listed.
Yes, yes.
Today
Only
only.
difference is that their license number is different, rest, the order, impugn order, the appellate order, there everything is same. And the ground is inquiry report is not furnished and discrimination because for 24 numbers they have allowed. So for our us lordship, we have been lordship.
So in this petition now, how many people are there?
One, only one. Because I have filed the amended petition lordship.
Okay.
Then there are 5 separate petition file.
Okay, we will allow this. So you are challenging that only the suspension order.
No, cancellation order as well as the appellate order because the appellate
Okay,
authority
cancellation
and appellate authority's order.
and appellate authority's order.
Yes, Lord, they upheld the cancellation order.
Hmm.
That order.
These 2 orders, right?
These 2 orders. This 1/7/2025.
1/7.
1/7/2025 is the appellate authority's order whereby they upheld the cancellation order.
Cancellation order is
January 2024.
22/1. Oh no. Where is the other order? 22/1/2024.
Yes, that order is upheld by the appellate authority by order dated 7/1/2025. So file this for setting it at what is order.
Okay, right. Heard Mr. A. Deka, the learned counsel, appearing for the petitioner. Also heard Mr. M. Chetia, the learned counsel, appearing for the state respondents. The instant petition under Article 226 of the Constitution of India has been filed by the petitioner assailing the order dated 22/1/2024 passed by the respondent number 3, whereby the PDS retail license standing in the name of the petitioner was cancelled. The petitioner has also challenged the order dated 1/7/2025 issued by the appellate authority that is secretary to the government of Assam, Food, Public Distribution and Consumer Affairs Department, which upheld the cancellation order dated 22/1/2024 issued by the District Commissioner Morigaon in respect of the petition. Full stop. The petitioner is a PDS retail licensee holder. Wide license number MS stroke PDS in bracket R 3 stroke 2007. Full stop. A complaint regarding misappropriation of rice by the agents of the FPS had been sent by an email dated 31/10/2022 to ADGP, VAC, Assam, requesting an investigation about certain malpractices being carried out by the petitioner. Full stop. After receipt of the email, and pursuant to the order dated 7/11/2022 issued by the Deputy Commissioner, Morigaon, the additional DC ADM, is it additional DC and ADM?
ADC Lordship, yes, DM.
Additional DC ADM,
Yes.
ADM Morigaon was instructed, was entrusted to cause an inquiry into the aforesaid allegation against the petitioner. Full stop. Accordingly, an inquiry was conducted by the additional DM Morigaon and the officials of FCS and CA on various dates like 11/11/2022, 10/11/2022, and 19/10/2022 respectively. Full stop. Which was the inquiry report?
Inquiry for Lordship. Type copy Lordship finance.
Page. Accordingly, an inquiry report was submitted.
32.
32 is okay. Inquiry report was submitted.
That's 3/12/2020.
Inquiry report dated 3/12/2022 was submitted before the Deputy Commissioner Morigaon by the Additional Deputy Commissioner and ADM Morigaon. Full stop. After receipt of the aforesaid inquiry report, the Deputy Commissioner Morigaon, by his order dated 22/12,
2022.
what is this order?
This is the tagging order. It is my consumers has been tagged with the nearby fair price shop as well.
Okay. After receipt of the aforesaid inquiry report, the Deputy Commissioner Morigaon, by order dated 22/12/2022, tagged the beneficiaries of the petitioner's FPS with the nearest FPS with immediate effect. It is contended by the petitioner that though the aforesaid order dated 22/12/2022 mentioned that the petitioner's FESD has already been suspended, but no such suspension order was received by the petitioner prior to the date of tagging, that is 22/12/2022. Subsequently, after the aforesaid order, the Deputy Commissioner Morigao issued letter dated 9/3/2022.
So it should be, sorry, 2023. 2023. It's wrongly typed of 2023.
You have written 9/3.
Because the signature,
Huh?
signature page 50.
No, your statement, what you're
Oh, yes,
stating.
sorry.
Deputy Commissioner Morigao, it should have been 23.
Should be 1923 because taking order is on December.
After almost 4 months.
Taking-
Okay. So where is the order, taking order?
Taking order is annexer 4 lordship 22/12/2020.
Page.
Page 43 type copy. Originally is page 45.
Here also you have written 22. Signature is 22 only.
22. 2012.
So why are you saying 2023?
So far
Or this is 22 is taking order.
yes, so cause is concerned.
So cause
We have
where?
written is 9/3/2022,
Now where is that?
page 47. But in the signature it is 9/3/2023, page 50 also. Obviously, it should be 9/3/2023.
Okay, you're right. The Deputy Commissioner Morigao issued a letter dated 9/3/2022 requesting sokoj within 7 days, which contain certain allegations about certain malpractices of the petitioner. Full stop. On receipt of the aforesaid SOCOS notice, the petitioner vide its letter dated 15/3/2023 replied to the aforesaid SOCOS notice, denying the allegations. Denying the allegations, full stop. However, on 22/1/2024, the Deputy Commissioner Morigao issued the impugned order whereby on the basis of the inquiry report submitted earlier by the submitted by the ADC and ADM Morigao. The license of the petitioner was cancelled with immediate effect. Full stop. Being aggrieved with the order dated 22/1/2024, the petitioner had approached the commissioner and secretary to the government of Assam by filing a statutory appeal on 26/2/2024. The same was the appeal of the petitioner was rejected by the commissioner and secretary to the government of Assam, food, public distribution and consumer affairs department by its order dated
7/1/2025. Page 85, 7/1/2025. Oh, sorry, 1/7/2025.
17/2025, upholding the order issued by the Deputy Commissioner Morigao. Full stop. In view of the aforesaid cancellation of his license, the petitioner has approached this court by filing the instant writ petition. Full stop. Mr. Deka, the learned counsel appearing for the petitioner, has primarily submitted that though the impugned order of cancellation was passed by the Deputy Commissioner, which was subsequently upheld by the Secretary, to the Government of Assam, Public Distribution and Consumer Affairs Department. But the same was done without providing the inquiry report to the petitioner. Full stop. He submits that since the whole issue of suspension is based on, whole issue of cancellation of his license is based on the inquiry report, a copy of the inquiry report should have been given to the petitioner to explain his position. Full stop. He submits that by such non-providing of the inquiry report, the principle of natural justice has been denied to the petitioner, and on that ground alone, the cancellation order, the impugned cancellation order, should be set aside. Full stop. In addition to the aforesaid submissions, the learned counsel submits that though inquiry was conducted against 43 persons, 43 persons on similar grounds How many were given this thing?
24.
24 persons. Against 24 persons, no action has been taken by the respondent authorities. Full stop. He submits that those 24 persons were also similarly situated as the petitioner in the instant case. Full stop. He submits that due to non-availability of the Aadhaar cards of various beneficiaries, there was some difficulties in maintaining the stock register, manual stock register. However, the stocks were distributed by using, what is that?
Biometric or EPOS, electronic point of scale.
EPOS.
EPOS message.
By using EPOS. Full stop. He submits that as far as the other 24 persons also, they too have used the same mechanism for distribution of stocks to the beneficiaries. Full stop. In view of the aforesaid, he submits that the petitioner being not in fault, and he has in fact been maintaining and distributing his stocks by EPOS, the cancellation of the license of the petitioner is not canable under the law, and therefore the same is set aside. Full stop. In this connection, the learned counsel appearing for the petitioner has submitted, and not right idea, in support of his contention that it is mandated under the law that inquiry report on the basis of which a penal action has been taken must be provided to the person against whom the order has been passed. He has referred to the case of Saha Alam Laskar versus State of Assam, in bracket WPC number 7474/2022, decided by Gauhati High Court on 22/3/2023. What is your submission?
Hello, please, this matter, we may be allowed to proceed after as per 13 of this judgment.
Okay. Mr. M. Chettiar, the learned junior government advocate, submits that since this since the Gauhati High Court has already held that non-submission of the inquiry report before taking any penal action is not the correct law, an opportunity should be given to the respondent authorities to go ahead with the inquiry. Now go ahead with the so-called notice after providing a copy of the inquiry report to the petitioner. Full stop.
Paragraph 13 matter request.
Can you write? In the case of Saha Alam Laskar Supra, a coordinate bench of this court in paragraph 12 held as follows. Just extract paragraph 12 from me. taking into account, next, taking into account the submissions made by the counsel appearing for the respective parties, as well as the decision of the coordinate bench of this court in the aforementioned case. This court is of the considered opinion that the instant petition merits interference of this court, and therefore the impugn orders dated 22/1/2024 and 1/7/2024 are hereby set aside and quashed.
2-5.
2/5 are hereby set aside and quashed. Consequently, since the impugn orders have been set aside, comma, the respondent authorities shall now proceed from the stage of interference by furnishing a copy of the inquiry report dated, what was the date?
22 December 2022.
Huh?
Inquiry report date is 22.
12/2022 to the petitioner, immediately, comma, preferably within a period of how many days?
15 days, madam.
Within a period of 15 days to enable the petitioner to provide his explanations to the so-called notice dated
Nine three 2023.
to the so-called notice dated 9/3/2023
2023.
within a period of 15 days from the date of receipt of the inquiry report. So within 15 days, you give him his copy, and after 15 days, he'll give a reply to you.
But he will oppose the authority, my lord, with this order, my lord. Immediately thereafter, they will provide them.
No, you give it to him. You are here. Okay, we'll do something on that. Okay. Okay, then you write, what was that report dated so and so to the petitioner. On submission, the petitioner on submission of a certified copy of the instant order. Then thereafter you continue with that, the remaining part. Then thereafter, within 15 days from the date of receipt of the inquiry report, is submit that you have written. No? In the event the petitioner submits his explanations, so you're not going to submit any explanations to inquiry report. You'll submit a so-called. Huh?
Already received the report which we get.
No. After receipt of the inquiry report, you will only submit the reply to the so-called notice. But you will take into account the report. That's what, isn't it? So in the event of petitioner submits his reply to his fresh reply to the so-called notice in consideration of the inquiry report within 15 days, comma, the respondent authorities shall proceed to consider the same and pass a speaking order to bring the process initiated by the so-called notice dated so and so to its logical conclusion within a reasonable period of time, comma, preferably within a month from the date of receipt of the reply of the so-called notice, comma, if so submitted, full stop. In the event the petitioner does not respond to the so-called notice after receipt of the inquiry report within 15 days, the respondent authorities shall be at liberty to decide the matter on the basis of the materials available before them. Needless to mention that the speaking order so passed shall be communicated to the petitioner forthwith. In the others are not necessary. If you are aggrieved, we can approach. Then you write. Okay, in terms of the aforesaid, the instant repetition is disposed of. I think that will do.
If required, petitioners may be heard and they may also be allowed to submit the relevant papers also.
Yes, so you give a so-called notice reply, then he replied a so-called notice, then they'll give an opportunity. I mean, they will go as per the law, and nothing should be mentioned. I think this will do. So similar order will go in other petitions.
Yes, 24.
Take down the names.
Only difference will be that license
Number
registration.
and the petitioner's number and the license number.
Yes,
That's all. Nothing else.
Yes.
Orders are same.
Same.
All impugn orders are same.
Yes. Item number 24,
24,
25,
25,
26,
26,
then in 57 and 58.
57 and 58.
That's
Sure. Pass me down. I'll just rise for 5 minutes. I'll just come back.
Okay. এতিয়া লাগে মোৰ হাততে ৰিলে আৰু একবাৰ মান আহো নাই আজি আকৌ এপ্লাই দিয়া নাই অলপ এই ভাল জানো মোক কিয় দেখিব নোৱাৰে বাৰু মই কি আপোনাক ভাল এইটো দিয়া বাৰু দে বাৰু কম বাৰু এতিয়া নকম বাৰু মই ইয়াতে নকম নহয় item 24, 25, 26 তাৰপিছত 57
Make please, your lordship.
Yes.
Minor this matter relating to the ex parte award of the permanent Lok Adalat Qatar Silchar lordship.
Hmm.
Petitioner before your lordship is the president of the Gaon Panchayat lordship.
Hmm.
She is, I filed my written submission also. What is it?
Yes, what happened? What happened?
What happened, lordship, some of the job card holder filed a complaint before the permanent Lok Adalat lordship
Hmm.
for non providing their job lordship as per FG and NREGA lordship,
Hmm.
for which they claim for wages lordship.
Hmm.
And accordingly, earlier occasions also, same with past and ex parte order, the petitioner Gaon Panchayat came before this.
No, petitioner was aware or not? About the local lot.
About the Lok Adalat lordship, that because officers are regularly changing, for which there was no such communication. I am coming page 75, lordship, may kindly peruse of my petition.
Hmm.
Page 74, last portion, lordship. May I read, lordship?
Yes.
Learned counsel on behalf of the petitioner further.
Page 75.
74, last line, then 75, lordship.
Learned counsel on behalf of petitioners.
Lordship
Ah.
has further submitted that the OP are deliberately absent in the proceeding and prayed for passing necessary award as per Legal Service Authorities Act. Then, lordship, third paragraph of in the same page, lordship, in the instant case, opposite party entered their appearance, so and so, but thereafter remain absent on perusal of records. It reveals that the sufficient opportunities were given to the opposite party for their appearance, but they failed to appear in the proceeding despite repeated notice, summons.
Hmm.
That being the position, this permanent Lok Adalat has left no other option but to adjudicate the matter on merit on the basis of the material available on record. As per section 21E of the legal services also reflects, lordship, the provisions are quoted. Then, lordship, page 76.
Hmm.
Upon the facts and circumstances of the case, this permanent Lok considered it fit to dispose of the case on merit on the basis of the evidence of the petitioners and on the perusal of the petition and written statement of the opposite party. As the opposite party did not participate in the evidence before this forum by adducing evidence, the opposite party have also failed to advance arguments in the case before this forum. By its conduct, the opposite party did not repudiate the evidence of PW1 by the enemies. So, on the basis of the materials available on record and upon hearing the petitioner's side, this forum considered the evidence of the PW1 makes the following award. The opposite party are directed to make the payment of the employment allowance to the petitioners at 1/4 of the wages rate for the first 30 days of the financial year and not less than half of the wages rate for the remaining period for the financial year, subject to the maximum of 5 years commencing from 2007 to.
Got it. Now, what is the problem with this order?
Problem is that, lordship, thereafter, the entire matter was referred to the civil judge senior division number 2, lordship,
For
making the as an execution for execution of the award. It's an money execution, page 79 to 83, lordship. Page 79.
9. Hmm. There what happened?
Then the learned civil judge, lordship, passed an award attaching the bank accounts and others. Attachment of the order, lordship, page 85, lordship. Page 83 back, kindly peruse lordship. Seen the report, Sabina Najib, so and so, so and so. So and so, seen the branch manager, so and so.
You appeared there.
No, yes, lordship, they filed a petition, lordship, for vacation of the, but that court cannot, lordship, consider the matter because since it is a money execution case
Hmm.
for which this writ petition filed by the
Where is that order?
that lordship, we filed a petition for vacation of the attachment order.
Hmm.
Lordship, page 92, lordship. Also seen the petition where so and so filed for defreezing the amount maintained, account maintained.
Page 90?
92, lordship.
92 is decree holder is represented.
Lordship.
Ah.
SR on the notice of JD issued to JD number 1 received till date, await the same. Report of the await issued to the attachment movable properties of the Gaon Panchayat, lordship, sir. Also seen the petition bearing number so and so filed by JD number 3 for defreezing the account maintained by the GP Secretary Shunapur, fixed on author for hearing on the petition, lordship.
Hmm.
What happens, lordship? As per the
Now after this, what happened?
After this-
2711.
after this, lordship, till date, the petitioner came before this honorable court, and this honorable court pleased to pass a stay order of the execution as well as the main suit, lordship, which was in the first day, lordship. (16A) Lordship, order dated 9/1/2026, lordship. My respectful submission, lordship, this case, lordship, as per act, lordship, that there cannot be an award without any compromise or agreement, lordship. Now, entire problem is that, lordship, the entire bank account of the Gaon Panchayat is freeze, lordship, for which the Panchayat is unable to, lordship, make payment of the various development works as well as.
Correct. Now it has been stayed, right?
Lordship,
Hmm.
though stayed, but the account which
Hmm.
was freezed by the learned court below, lordship, the civil judge, lordship,
Hmm.
that was not till date not open, lordship, and for which the petitioner's entire Gaon Panchayat.
But that order is already stayed.
Stayed,
Freezing order.
But the learned court below did not consider, the bank is not accepting that order since it was stayed, but they are.
Oh,
not
I mean,
opening.
the freezing order has already been stayed, then what remains?
That clarification, lordship, I pray, lordship, because once the stay order is there, entire things has been stayed, but because of the learned court below's order, my money execution case, lordship, the bank is not allowing us to operate the bank account of the Gaon Panchayat, lordship.
Have you filed any representation?
Before we filed the executing petition before the executing court, lordship.
Where is that?
That, lordship, in the IA, lordship, which was closed by IA number 216, lordship. A page number, lordship, 33, lordship.
Then where is the order?
Then next page order is the lordship, the page 36 is the order passed by in the money execution case, lordship, by the civil judge senior division number 2 Kachar Silchar, lordship. My lord, the copy of I is not served to us. And my lord, and what will be the compliance of the order of the permanent look at the order?
Hmm?
There has been some court's order. Order was passed in a due process. And my lord, my friend has read one part of the judgment of the court below, but not the whole
But
part.
that order has already been stayed. Then that order, the consequence of the order is that the bank accounts which have been freezed by them, that should have been cleared.
My lord, then what will be the complaints of the order? My lord, they are not complying the order. My lord,
No, forget about compliance of order now. They've approached this court, High Court. High Court has stayed it after hearing them.
my
And
lord,
and if the bank accounts have been freezed by that order and that order has already been stayed, what is the consequence?
my lord, now the matter has.
See,
come
I mean,
up. My lord,
you see the interim order. Interim order you have to read as a whole, right?
the copy has not been given to, my lord. No, the IA has, you have filed an IA, the copy has not been served to us, my lord.
On that time, lordship,
Why haven't you filed, given him the copy, IA?
IA lordship, that was
IA has been filed for what? Vacation?
lordship for vacation.
Vacation of the what?
Vacation of the, not vacation, but
Modification. But you have not given him the copy.
Actually, copy has given lot, but the things is that IA lordship was closed for disclosing the entire matter, lordship. On that day, my learned friend was also present. He appeared, lordship. I am, with all respect, lordship, I am praying for, since it is an ex parte award.
My lord, my friend,
Now, what was the order passed in WPC 116/2026? This interim order.
Interim order.
He mentioned about this.
Lordship. Some
No further,
clarification to the direct the pay
my
or
lord,
to
when there is an order to hear the matter entirely, my lord, my friend is my lord, pressing for the IA, copy of IA.
No, I can give, but one thing is that lordship, the only things I am pressing before this honorable
My
court
lord.
is that to open the bank account, lordship, otherwise the entire
No, your IA already has been closed.
lordship, but
Then what
but
can be
just
done?
I-
I cannot modify that order.
lordship, I am not on entire matter may be hard since my learned friend has filed his affidavit, lordship.
So we'll
Also,
fix up a date. It will take some time.
My lord,
Lordship is short because the money entire
Understand. But then you should have pressed for this IA.
lordship.
Why didn't you press for the IA? Why didn't you impress upon the court that an interim order is very much required?
Actually, on that day, lordship, my learned friend also appeared, lordship, the court.
I'm not, whether he appears or not, it is your case.
His affidavit also,
That is, see, this is your application.
lordship,
You have filed the IA.
lordship.
So you should have pressed for this. That interim order is required, modification order is required, but that has already been closed and I cannot reopen that.
Lordship, that apart, lordship.
my lord, the whole petition is not maintainable. The party who are affected, the deputy commissioner, the panchayat secretary, they are not party before this court.
Actually, what is
the
it?
petition has been filed by the panchayat president.
Okay, that, I mean,
It is the private
this matter has to be heard finally, so we'll put it up for hearing. Maybe after 2 weeks.
It can be part of, maybe part
No,
of.
not part heard. How can it be part heard? Why?
Lordship, admission hearing, because otherwise it will take more time, lordship.
Heard Mr. K.M. Majumdar, Lalanan Senior
And
Counsel,
some observation I
assistant
say,
here,
lordship,
so and so,
regarding the bank account.
for the, for the petitioner. Also heard Mr. S.K. Siddhar, the learned counsel, appearing for respondent number,
My lord,
All
all
the
the
respondents.
private.
for all the respondents, full stop. Mr. Majumdar has shown some urgency in the matter. Let the matter be fixed for admission hearing. On 16 June.
Lordship, till lordship,
Or
before
16,
that,
no, make it 15 June.
lordship, I pray one thing, lordship. Let some observation maybe for handling of the bank account, lordship.
No, that will be decided, finally decided.
I am, lordship, only on.
See,
that,
Mr. Majumdar, you have filed an IA for modification of the order. and that was heard and that was closed. Now what modification I can do in this case?
Not on.
It has to be
the
heard.
Main interim order, lordship, only on.
That's what main interim order, he wanted modification in the main interim order only.
Only that bank operation of the bank account.
That is
Since
the-
it is
the-
Already stayed.
That is why you have filed the IA has been closed now.
Lordship did.
Then
They are urging for the modification or alteration of the.
No, entire
interim
matter,
order.
I
no,
am
they have,
ready to
Mr.
hear
Siddhar,
not-
Mr. Siddhar, see, you cannot deny one thing that whatever order has been passed, but the other people also suffering because of the freezing of the account, isn't it?
What about the petitioners, man?
The
They are
peti-
not looking after, man.
the
Lordship, it was an
petitioners,
ex
you have
parte
come,
award.
petitioners will see, but the people who are not at all at fault, they are suffering.
Because of their fault. Let them, let them.
Mr. Siddhar, somebody is not before the court. They are not at all, they are not in the dispute itself. And they are being suffered because their accounts, because the account has been freezed. So they are not getting salary. Is their fault? Is it their fault?
I admit that.
Correct. So
But-
that's
but
what,
the
that's what I'm
responsible-
saying.
My submission is the responsible authorities.
The responsibility,
also
authority,
complete the
whether
report,
whether
complete the
they have
order.
done something wrong or not, that will be adjudicated upon. That will be done. But thing is that why he is pressing is that like other people also suffering. That is the thing. So we'll see it. We'll look into it. But the matter is taken.
On 15th, lordship, 15th June.
15 June. 15 June.
It's entirely
We'll take it up.
expert order.
And you, that's, I mean, that copy of that is not required now because it's already disposed of.
Lordship.
Do you, if
necessary,
he,
I
if,
will
you give him
copy.
a copy.
Lordship, for his lordship.
28.
My written submission may be kept in the record, lordship.
Yeah, it's there.
Lordship.
May it please the Lordship. The petition is for inaction of the respondent authorities.
Hmm?
This petition is filed for inaction of the respondent authorities for appointment
Next of the respondent authorities for
appointment of a special public prosecutor to conduct a trial under the POCSO Act.
But is this mandated under law that
Yes, my lord, as per POCSO Act under section 30.
no, in that particular code, designated code, there is no public prosecutor.
For conducting the POCSO case, my lord, there has to be a special public prosecutor.
But that public prosecutor can be also probably designated.
Cannot, my lord.
Huh? That has to be recognized. That is there in the POCSO Act itself, section 28 probably.
30, my lord, kindly see section 28.
But before my
Ah.
senior friend proceed, this case has been looking after by Dina. He is due to some person because he could not appear.
Hmm.
As per my instruction, some instruction has been received with regard to the appointment of the PP minor.
Okay.
So he's asking for a date for next week minor, either Wednesday or Friday night.
Okay.
And,
Chaudhary?
My
There's
senior,
Go
We
ahead.
have filed an application, I am the accused.
Mhm.
I have not been even made a party, there has been a lot of hanky-panky going on with regard to appointment of the special PP. We have filed an application for implement, that implement may be allowed and we may be given an opportunity, this has been filed quite some time back. We filed it.
We have serious
we got a
objection on this.
Strong objection.
Hmm?
Because he is appearing for Malana, senior friend is appearing for an accused and the trial is going on. And what right he has got to say something with regard to the appointment of the PP man?
This,
Let it be taken up together on next Friday, my lord.
but my friend, this itself goes to show that there is a serious hanky-panky going on. We have had to file a writ petition, which is pending. That aspect is not even brought on record.
No, my lord.
And there was a attempt made to violate the law and appoint a PP at the instance of the writ petitioner. This writ petitioner appears to be a very powerful person, having deep connections in the government. That is why the government is also,
Next Friday, my lord.
yes, but the implement has to be allowed. I am the accused. I have filed a writ petition separately, which is pending well, on this very issue.
So we have serious objection in that way. But my lord, may kindly see our prayer.
Next Friday. Dina, this will be.
Which court is this? Gauhati,
Session just Tifu, my lord.
Diffu. No one has been appointed till now. No one has been designated
One,
as special public
there was a
prosecutor.
public prosecutor, because of his old age, he resigned. Thereafter, since 2025 June, there is no public, special public.
Your lordship will just come to page 87 of the writ.
Not only.
That
this
will
case,
indicate the mischief that I was talking about. Your lordship will just have a look at page 87.
Page
87. Your lordship will find that I am the writ petitioner in this. And your lordship will kindly turn to page 89. The last paragraph,
89.
page 89, the
Okay.
operative portion of the order.
Having considered the recommendation.
That is why my implement is necessary. The deputy commissioner intervenes to appoint. He seizes power from the state government without jurisdiction, and it had to be ultimately interfered with, and this writ petition is pending. So my prayer at this stage is our implement may be allowed, and this writ petition may be tagged along
Okay,
with.
we'll do one thing, Mr. Chaudhary. I mean, we'll hear the matter on Friday only. He's saying that
Fine.
Friday we'll hear.
Fine.
Friday we'll hear it. Okay, heard Mr. H.K. Nath, the counsel for the petitioner. Also heard Mr. I. Chaudhary, the learned counsel. You are not implemented as it.
Not
You have filed this IA.
I.
Chaudhary, the applicant, appearing for the applicant in IA number, IA civil number 739, filed in the connected writ petition. Also heard Mr. N. Das, the learned government advocate for 1, 2, 3, 4. Mr. N. Das submits that in the instant case, Mr. D. Nath is, Mr. D. Nath, the learned senior government advocate, is appearing. However, due to certain personal difficulties, he could not be present in the court today. He prays for a short accommodation, full stop. On the agreement of the parties, let the matter be fixed on Friday.
29. And this may be listed along with my writ petition, my lord, WPC number 6672, same issue. That there also the issue is appointment of special people.
Okay.
WPC
then,
number 6672.
Then you write, Mr. Chaudhary, the learned senior counsel, submits that a writ petition, that is WPC number
6672.
WPC pertaining to the issue of
Of
appointment of special public prosecutor POCSO in the special court POCSO DIFU. Also, we praise that the matter, since the matter is he praised that he praised for listing of the matter along with the instant writ petition. Let the WPC number so and so be listed along with this matter on Friday.
All right.
On this and so and so.
Obliged.
Okay.
Obliged.
Party.
Okay, heard Mr. M. Sheikh, the learned counsel appearing for the petitioner. Also heard Mr. N. Das, the learned counsel appearing for the state respondents.
Yes, ma'am.
2, 3, 4, and 5.
My lord, 2, 3, 4, 5.
2, 3, 4, and 5. Mahanta appearing. Mahanta for 1. Mr. Das submits that he has received the instructions and prays for 2 weeks time to file
Yes, sir,
affidavit.
ma'am.
2 weeks time to file affidavit in the instant case.
My lord, not 4 weeks. Let it be 3 weeks.
Why to 3 weeks is required?
My lord, this case is subject.
Okay, let
It's not even a landless person.
3 weeks time is granted. Let the matter be listed after 3 weeks. Let them file affidavit.
My lord.
That is your lordship. Your lordship, regarding item 52, before coming to the depth of the matter, lordship, before coming to the depth of the matter, lordship, here Mr. Senior Counsel, Mr. K. N. Suri is appearing in 52, item number 52. So I pray for some time for lordship. He is out of station, his name is appearing.
He is appearing in this matter.
Yes, lordship.
52.
52.
You are for whom?
Respondent 7.
Respondent, private respondent.
Yes, lordship.
In all the matters.
No, in item number 52, respondent 7.
So Mr. Chaudhary is appearing in this matter. Okay,
I pray for some time, lordship.
okay.
Lordship, our main grievance is against the Bakijai department.
Understood.
So the rule is very limited, and if your lordship is allowing adjournment for item number 52, I would take your lordship to item number 53 and 54.
All the matters will be heard together. It cannot be heard, separately.
Lordship, in item number 54, the state are yet to file an affidavit.
Alia,
So-
let's see what.
Vijay Talukdar, senior advocate, he is appearing in the matter, madam. Vijay Talukdar, senior advocate, madam. He is
I don't know
appearing-
why affidavit is not filed.
I'm not particularly handling this matter, because I am seeking adjournment on his behalf because he has some legal issue he has already filed.
Okay.
On instruction.
So we are posting it after 2 weeks. Let them file affidavit by that time, and Mrs. Chaudhary is also not there. He's seeking it.
May I pray for a fixed date?
Wait, please wait. I mean, heard MS so-and-so, the learned counsel appearing for the petitioner. Also heard Mr.
S.A. Bhatia for respondent 7 item 52.
2052. M. Borman, government advocate, appearing on behalf of whom? Mr. Vijay Talukdar. Vijay Talukdar, respondent for respondents, for state respondents, full stop. Mr. So-and-so submits that Mr. K. N. Chaudhary, learned senior counsel, is conducting the case, and he is not present today in the court to conduct the case, full stop. He prays for some accommodation, full stop. Next where I write, Mr. Borman submits, MS Borman submits that she requires some time to 2 weeks time to file affidavit in item number, affidavit in lead petition number
1546 of 2026.
1546 of 2026, full stop. Full stop. Let the matters be listed on 21st May.
What?
21st May.
20.
Oh, sorry, 21st June, sorry. No, 21st June, no. It will be 25th of June.
Lordship, may I pray for 15th, 25th will be.
18th, no, 18th, a lot of matters have been fixed already. They will be on 23rd of June. 23rd of June.
Lordship, also updated case status of the Bakijai proceeding may be called for.
Let them file an affidavit first. State file an affidavit. They may come up with the status.
Okay.
Thank you. My lord, this matter, we are challenging the order passed by the National Highway Authority of India, debarring the petitioner, who is a road safety consultant. Thank you. The lordship will find the reviewed order as P57 of the petition.
Yes, what happened?
In this matter,
You are challenging
challenging the order passed by the NHAI
NHIAI, okay, Authority of India,
in Authority of India.
not corporation.
Not corporation. Debarring the petitioner, who is the road safety consultant for a project for construction of a flyover in
He is the consultant engaged by whom?
NHI.
Hmm?
NHI,
NHI, he's their own consultant,
own consultant.
correct. Then?
There's a process of engaging this.
Correct, they must have a panel of consultants.
Yes.
Okay, now you have been debarred
I have been debarred.
because of certain allegations.
Certain allegations, there was an accident, and for this purpose, this order was passed, debarring me for 1 year. And this order was passed on 9th of June 2025.
What were the allegations?
The lordship will see. Basically, from the order, we could not find anything which is attributable to us. Page 357 is the order.
Why this thing is so bulky?
57.
Can I pray, Lordship? In this case, Mr. B. Soikia is appearing. In senior counsel, B. Soikia is appearing, Lordship.
Okay.
So we have some problem to the difficulties. Can it be taken up on next Tuesday, Lordship? Or it will take some time.
If your lordship takes it as a first item, because it will be expired on 9th of June. The 1 year department will expire on 9th of.
So 1 year department will go. So, I mean, what will be the consequences of this if it is not set aside?
If it is not satisfied, there is
No,
a.
it is not set aside, then what will be the consequences on you?
There will be a stigma on the corporation.
Is there any future, I mean, huh?
Yes. In
Future consequences are there.
yes, yes.
My name will be, sorry, I'm for the item number 56.
So they have debarred many.
Okay, many of the consultants.
Many of the consultants.
Consultant, he is
He is safety.
I'm for the item number 56 also. I am also similarly situated.
Who are you? You are also a consultant?
Yes. I'm
You have also been debarred
debarred.
for the same project
Same project.
Same project.
because of the accident,
Excellent.
because you advised them.
No.
And
No, no.
then
The role of the persons are different. My role is I am appointed by the NHAI, and my role is only limited to for the this thing for the drawing purpose at the stage of initial stage only, not later for after implementation of the road safety.
but your
measures.
drawing was bad.
No,
Your drawing was not
No.
not as per the
that
norms.
is not the allegation. That
Hmm?
is not the allegation. Most surprisingly, that is not the allegation, and that is not the fact.
Okay, we'll take it up some other day.
But
It's expiring in 9 June.
9th of June.
9th of June. And moreover, your lordship will also appreciate lordship in both the cases. In my case, they have filed an opposition, affidavit in opposition, wherein they have for the first time stated that there was an inquiry conducted by them, on the basis of which I was debarred.
Good, you have a good case.
Yes,
And
that is
then-
why.
And
Then if inquiry was not given to you on the
No,
basis
no,
of
no.
that they have taken some action, then it's a
Exactly.
good case.
No whisper also in the.
Then good, we'll hear you.
as that expert committee report
Hmm.
clearly says that should not be used. The lordship will see that there is a disclaimer in the inquiry report at page 409. Running page.
What you read out?
It states out that any use of the findings of this report
Hmm.
without the permission of NHAI by any other agency or person other than NHAI shall not be permitted. And the next line, any use of this report for legal purposes shall not be permitted unless prior written permission of the expert committee is obtained. Here no permission has been obtained, but relying on this report, they have debarred us without even allowing us to participate in the inquiry proceeding.
Okay, then when do you want it to be fixed?
Next week.
My senior will be available this Tuesday, Lordship. Next Tuesday.
Next Tuesday is will be.
The lordship can also consider 27 lordship, because now 28 is supposed to be completed. Right?
Okay, we'll put it on next Tuesday, 26th.
26.
As agreed by the parties, as agreed by the council appearing for respective parties, let these matters be listed on
28, my lord, because I'm
28 is a holiday this time.
27.
27 will be miscellaneous day that day.
Let us give a try.
I think 26 you're not there.
I'll be out of stage.
Okay, then we'll put it on 27th. Okay, 27th.
Interim.
Interim orders so passed earlier shall continue till the next date of listing.
Obliged.
Obliged.
Okay, record her names. Yes.
May I please, your lordship?
Who has not filed affidavit?
The bank.
Why? Why? Indian Bank is ahead of everything, above everything, what?
No, your lordship, that is not the case.
Hmm?
Basically.
No, that is the attitude.
And
That
which
is the
one?
attitude.
Sorry, for-
That is the attitude. Rupees for 5,000 paid.
Yes, your lordship.
Hmm? 5,000 paid. You are appearing for whom, Mr. Sharma?
For this,
You are appearing for the bank.
for the bank, your lordship.
My lord, may I kindly have a look at the conduct of the bank? On 30th March, they're saying that the loan was taken.
Why this personal appearance was given?
Your lordship, in the order, it has been written in the event of non-filing of the affidavit by the
Hmm.
next date.
Then have you filed affidavit?
No, your lordship.
Why?
Because your lordship, what was happened, that the matter originally belongs to Madhapur branch.
Hmm.
And we are searching the document at Duliajan branch.
Hmm.
And that caused a heavy delay to us.
Hmm.
Because the NOC was issued from the Duliajan branch.
Hmm.
And the son of the petitioners has taken various loan facilities also. That creates a confusion on the part of.
Now what is the thing? Now what is the state?
Your
Says.
lordship, their document is being at State Bank of India. Because the State Bank of India has issued a sale notice in this property.
So documents are with State Bank of India.
Yes, their main claim is that they have satisfied the loan, but the bank has not given them
Given the NOC to them.
document. No, NOC has been given.
Given.
That is attached,
Ah.
but the original loan property documents has not been given.
Huh.
Returned. Which
No,
they
it was with which bank earlier?
Indian bank.
Huh?
Indian bank.
Indian bank.
Mortgage with the
Now
Indian
now how this, no, I could not understand them, but see, documents were deposited in the Indian bank.
Yes, Indian bank.
They have taken a loan, the loan has been repaid. Loan has been repaid, documents were supposed to be with the Indian bank.
Your lordship, loan has been taken by Suren Sekia
Hmm.
and the Bulbul Sheikh.
Hmm.
Thereafter, after the death, the Manju Sekia, the writ petitioners has come into play.
Hmm.
But what was happened in the meantime, that the Bulbul Sekia, the son of the writ petitioner, has take away the facility from the Indian bank. And Indian bank, State Bank of India has issued a sale notice in the property,
Sale notice for what?
in the state property in which the original documents has been cleared. So we have written a letter.
No, why sale? Why sale?
My lord, what has happened is that in.
No, why sale? You just
My
give
lord,
me answer.
Phil, we are not at all involved. That is
Hmm.
my son which is doing all these things, and we have filed the title suit also before the competent
That
court.
is
That's
the-
the reason, my lord, we
Now
require
the
the
truth has
papers.
been come out.
No, my lord, we require the papers because of that reason. 2017, the loan was closed. They ought to have returned the documents there and there itself. They did not.
Either your lordship, State Bank of India may be party in this
My
case,
lord, why will State Bank
or
be a part?
Your documents are not there. What will you do? How they are going to give it?
My lord, it ought to have been with them. We closed the loan. The petitioner were number one.
there are 2-3 loan, your lordship. Suren Sekia originally owned 1 kattha 10 lacha and 16 lacha in the same dak number and pata number. And in 16 lacha, we are still processing the surface notice. And in 1 kattha 10 lacha, in which they are claiming the original title deed, that is in the Madhapur branch, and that loan facility has been taken away by the State Bank of India. And both the writ petitioners and the writ petitioners.
So you file an affidavit
Yes, my
stating all these things.
Yes, your lordship.
Then if the court will consider, then the court will see whether State Bank is required to be made a party or not.
Yes, your.
Very well, my lord.
Hmm?
Let
Let them come up. Let them come
Yes,
up.
my lord.
Okay, we are giving.
Yes, my lord.
Besides that, the Jamabandi, we have also obtained the Jamabandi.
You bring all these things on record. See, first thing is that liability is yours
Yes, your lordship.
because
That is
the documents were with you.
Yes, sir.
Now, how documents have gone to some other bank, you'll have to give an
Yes, I have to
explanation.
explain all.
So explain all those things and bring all those things on record.
Yes,
Then
sir.
we'll see what is to be done.
Yes, sir.
Right, heard Mr. S. Mitra, the learned counsel appearing for the petitioners. Also heard Mr. M. Sharma, the learned counsel appearing for the respondent bank. Your name? Mr. Bolen Chandra Bhattacharya. Boro, Bolen Chandra Boro, BOR of Indian Bank. Indian Bank is personally present today during the proceedings of the court. During the proceedings of the court, his presence is dispensed with from today. Full stop. Then you write the learned counsel appearing for the respondent bank submits that he requires he requires some more time to file a detailed affidavit explaining
The whereabouts of the original document.
explaining his stand in the instant case, full stop. His prayer is allowed, let the matter be listed after 3 weeks.
My lord, may kindly fix a date.
No, 3 weeks, 3
My
weeks.
lord, they have been doing this for the last four, 5 occasions, my lord.
Mr. Mitra, wherever we can give dates, we always give dates. But certain things like where we cannot give dates because of the certain reasons. Because like let them file the affidavit, once pleadings are complete, we'll give dates. But once pleadings are not complete, then it becomes difficult. But usually, see, like usually, I mean, after I'm sitting in this court, I have not seen any case where it did. I mean, where 2 year listed after 2 weeks, and it has not been listed for many. Nothing happens like that.
No, my lord, I
Uh,
appreciate it.
That's
Sir,
why.
they
That's
have
why. I
been
mean,
taking
if an order has been passed, listed after 3 weeks, registry is always places.
My
it.
lord, may just kindly keep a cost on them because my lord, they have been taking time and time and time. That's the reason, my lord.
We'll see next time. We'll see. The bank is a rich bank. We'll see how much cost to it. Already 5,000 is
Yes,
paid.
my lord.
You need some more money.
Not to me, my lord.
You want to
it may
earn other than lawyer's fee. In addition to that, you earn some money out of this also. Okay.
my lord.
Very good.
Yeah, please, Your Lordship. Lordship, in this case, we have filed our affidavit in respect of the Lordship.
Your reply to that.
Yes, Your Lordship.
Hmm.
And
What is your replies? Let's see the affidavit.
it starts from page number 73,
Affidavit এখন answer.
paragraph 3.
আনো নাই কিয়? ৰাতিপুৱা mention কৰিছে। Oh, thank you. Additional affidavit you filed or reply?
Yes, additional affidavit.
Huh?
That is affidavit in reply. Page number starts from page number 73. Your Lordship.
Yes.
Paragraph 3.
Hmm.
I have mentioned with reference to the statement made in paragraph 5 of the affidavit in opposition, the deponent backs to state that admittedly the aforesaid land was owned and possessed by Robinson Gogoi, and thereafter the said land was transferred to his legal heir Babulal Gogoi, and thereafter on the death of Babulal Gogoi, the said land had been transferred in the name of Jayantojit Gogoi and Hiren Gogoi. Accordingly, Miadi Patta was issued by the District Commissioner Lakhimpur and Jamaband.
Mr. Sharma, we'll take it up in the next week. Okay, there are some other matters are also there. I mean, this case has to be disposed of. So next week we'll dispose it of. Monday?
Difficulty is that Lordship, the petitioner's family has been suffering because
Yeah, I
their
understand
mother
that.
is
But
Lordship about 90
see,
years.
Mr. Sharma, this has to be disposed of, correct? Now bleedings are complete, we'll need to dispose of this matter. Disposing of this matter, we'll have to hear you as well as pass the order. So we'll fix it up on Monday. Monday, we'll dispose it of.
Part, it can be fixed at part because yesterday also your Lordship has heard.
Okay, we'll keep it at part heard and we'll dispose it of on Monday. Okay?
Monday, Lordship, it will be a virtual hearing, Lordship.
Virtual hearing, so what? Virtual hearing, but
Yes,
I mean, it is encouraged virtual hearing. Virtual hearing is encouraged. So you understand what is the meaning of encouraged?
Yes, sir.
Hmm?
Only the
So-
problem is that Lordship, the mother of the petitioner says.
I fully appreciate, but only thing is that the time is less. There's a lot of matters are there. And if I hear your matter and pass an order, then other matters will be left out. That is the thing. On Monday, we'll hear your matter. Okay? Okay. All right. Parties are duly represented. Let the matter be fixed on 25th. 25th of May. Or if you want Tuesday also, we can fix it.
Tuesday, it can be on Tuesday.
If you're thinking that the virtual thing is difficult for you, then
Yes, yes,
okay, let the matter fix on 26th.
Highly okay.
By appeal, Your Lordship.
My humble prayer, Lordship, matter may be fixed on next Tuesday, Lordship.
Next
Tuesday, Lordship.
Tuesday, why?
My seniors left the court, Lordship, some
Hmm?
medical emergency.
But you have been taking time all throughout. He just come for what? Admission hearing? Or it is, huh?
For admission hearing.
Petition hearing.
Why it has come under stay? Stay, stay. Is there any,
So criminal petition, proceed the complaint.
hmm. No, is there any stay there? Oh, since there is a stay order, that's why it is coming.
NI city.
Okay, okay. Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be fixed. Fixed on when?
Well, state is a formal party here also, because it's NI.
Let it be after 2 weeks. After 2 weeks. MS SH Bora, the learned APP is present for the state.
Please.
My lord, I filed this criminalization petition 2014. So from 2018 onwards, I am not in contact with the petitioner. So I tried my best.
2018,
18 onwards.
then you dismiss it.
No, yeah, Your Honor, I have to withdraw the Upalatama. So in that figure, I may be given time so that I can send a notice to him, and next that I can submit the copy of the notice and others.
What is the case, mister?
In this case, I filed a complaint case. And
NI
I
case.
explained.
NI case.
Your Lordship, and in that case, he is convicted in the trial and appeal also dismissed. And there is admission on his part, Your Lordship,
But only thing is that it's a little problem for me to take up the hearing. Because, my lord, now almost for 6 years. Even though he has a.
You could not communicate with him at all.
No, I have.
Address is changed.
He has a shop at Panchi Bazaar.
Hmm.
I think he may be knowing. So I have gone to that shop also. He's not there.
He's not there.
No one
There-
knows about him.
No news, nothing.
So in that
And
case,
conviction for how, what is the period?
2 months. 2 months and fine of rupees 3 lakhs.
So what is to be done, mister?
Maybe given a chance.
since 14 it is pending, Your Lordship.
Then what is to be done now? The person is not there.
Your Lordship.
We allowed to send a notice so that I can submit a notice on the next.
Huh?
It may be allowed to send, serve a notice upon him, on his address, whatever is there, so that I can submit for the honorable court on the next in my court.
But this address, nobody is there. I mean, who will receive your
We know
notice?
his telephone also, we will have telephone earlier when I telephoned, source with off, switch off, switch off.
Okay, right, Mr. So-and-so, the learned counsel appearing for the petitioner submits that since 2018, he doesn't have any connection with the petitioner. He submits that in spite of his best efforts, including his personal visits to the shop of the petitioner. The shop is still there.
So, but somebody else has taken over.
To the his personal visit to the shop wherein where from the petitioner was operating earlier. He could not make any contact with him. He submits that the aforesaid shop has been taken over by somebody, some other person. In view of the aforesaid, he submits that he should be allowed some time to serve a notice upon the petitioner for withdrawing from the case. Full stop. He submits that upon service of the notice, the same will be placed before this court for consideration of this court. Full stop. Let the matter be listed. Mr. So-and-so is appear. Mr. Jha is present for the respondent. Then you please write. Let the matter be listed when? After 4 weeks.
Yes.
In the meantime, you again try once.
Much obliged.
Lordship, I have filed this petition challenging the judgment passed by the learned Edison CGM, Morigaon in Nagaon, in GR case number 1148 of 2029, where he was convicted of
Mhm.
he was convicted under section 304A for a 1 year with fine of 2,000 and 279 for 3 months and fine of 1,000, and then under section 337 punishment of 3 months and fine of 500 rupees. I filed an appeal, then appeal was again confirmed appeal the judgment, conviction. So now I have come on relief.
Today, will it be possible?
No, it's not possible. The LCR has been received, so it can be fixed for hearing.
Respondent number 2 is also
Not there.
not there.
Okay, heard your name?
S.M. Rahman.
Heard Mr. S.M. Rahman, the learned counsel for the petitioner. Also heard Ms. S.H. Bora, the learned APP for the state. None appeared for the respondent number 2 when the matter was called for. TCR in the instant case has already been received. Let the matter be listed after 3 weeks or after 3 weeks for hearing.
Final hearing.
Obliged, Lord.
After 3 weeks. for hearing.
34.
Please, Lordship, the forcing application, Lordship, for forcing on NI case.
Hmm.
Time will not be possible.
Yes, today it will be little bit difficult.
That's why.
So when do you want
The date
it?
of hearing?
Huh? When do you want it?
After 2 weeks. After 2 weeks.
Okay, heard Mr. D. Talukdar, the learned senior counsel assisted by so and so for the petitioner. Also heard Mr.
B Sinha.
V. Sinha for
Respond number 1.
respondent number 1. Okay. You were also there? Bora, you were there?
State formal party.
Okay.
Asa.
On the prayer of, on the joint prayer of the parties, let the matter be fixed after 2 weeks.
Interim order is.
Interim order so passed earlier shall continue till the
Marks.
next released.
35.
Pleasure, Lordship. Question petition regarding the criminal proceedings currently being stayed in respect of the petitioner before the Honorable Learned SDGM Margarita in complaint case CR 22 of 2019. Lordship, in this matter already PCR has already been received.
Anybody is appearing for 2 and 3?
In the earlier occasion, instruction was sought for as regarding the service of notice of respondent number 2 and 3.
Hmm.
So that report is awaited, Lordship. Needs some time.
Okay. Okay, right. Heard Mr. W. R. Medhi, the learned counsel for the petitioner. Also heard Ms. H.S. Bora, the learned APP for the state. Ms. Bora submits that she is yet to receive any instructions regarding service of notice on respondent number 2 and 3. She prays for further time of 2 weeks. Let the matter be listed after 2 weeks.
Interim to be continued.
Interim order so passed earlier shall continue.
Obliged.
Obliged.
36 orders.
Mr. Narayan.
May please, Lordship.
Yes.
Which notice has been served upon respondent number 9, madam.
Hmm?
As per the order dated 18/5/26.
18/5?
2026.
18/5/2026 order.
Yes, my lord.
Where is 18/5/26 order?
Lauzima court order.
Huh? Lozima court order only 6/11/2024. You are not appearing before the Lozima court. where have you found this 26 order law Supreme Court?
Online, my lord. E-court. Yes, showing, my lord. E-court showing.
E-portal,
Yes, my lord. 18/5/2026.
hmm?
Portal,
18/5,
2026.
2026,
Yes,
but
ma'am.
there is no order here.
But portal is showing, my lord.
Whether you appeared,
No, my lord.
who appeared then? Who appeared? Somebody's name must be there, you read out who appeared.
Non-appears on behalf of the petitioner, my lord.
Then,
Then law Supreme Court order passed 18/5/2026.
27,
26, my lord. 18/5/2026.
then what was the order passed?
Deputy Registrar, Mr. Saptashi Das.
Anybody appeared from your side?
No, my lord.
But there is no record here. And you are not appearing before law Supreme Court, you are not taking steps also.
But there should, showing, my lord, notice has been served upon respondent number 9, my lord.
There is no record here. You are appearing in which matter? Item
36.
number?
36.
There is no record here. What is your name?
A Hussain, my lord.
A?
Hussain.
Heard Mr. A. Hussain, the learned counsel for the petitioner, also heard MS M. Kumari for special public
Number 5.
prosecutor CBI. Correspondent of 5 year. Name take down, Ms. Sharma is there. Mr. Sharma 6 and 7. Oh, there is one order. ये order मतलब आप किसके कोर्ट के लिए? यहाँ तो कुछ ना order मतलब लगभग इनके पे लॉजिमा कोर्ट order. याद दूता order. याद इसे ये माजब की इबला लॉजिमा कोर्ट order. याद की तो order. The एक ही तो order साले एक ही सब लोग लगाए. ये तो फॉलो वाला Okay, then you write seen the Loazima court proceeding on dated 18/5/2026, which reveals that service of notice upon respondent number 9 is complete. Let the matter be listed for admission hearing in usual course.
Just let me.
You should appear before the Loazima court. Okay, and like you have not appeared on a single date in before the Loazima court proceeding happened almost 4 times, and now you are asking for a date. It should be assumed. You should participate in a Loazima court proceeding when you don't serve notice. None appears for the petitioner when the matter was called for, though Mr. N. Das, the learned counsel for the state respondent is present. Let the matter be listed after 3 weeks.
30 to 41, my lord, these are the analogous matters.
On the last occasion, 37, state is not there.
Hmm?
State was not there.
37, you are not there. Who is there? You are appearing for whom?
I mean 38, I thought 38.
Okay, then you write none appears for the parties when the matter was called. Yes, sir. What happened in 38?
38 and 41, my lord, the service is complete.
Hmm.
In fact, there's a Lawazima order dated 7/5/2026 in item 38. 39 and 40, my lord, service is not complete. So, my lord, 39, 40, we will take fresh steps and additionally we will take dusty, my lord, in 39 and 40. 38 and 41, the service is complete.
So you take fresh steps on dusty. Why dusty?
If necessary, or we'll take just normal registered post with AP, as your lordship desires, in 39 and 40. 38 and 40, my lord, service is
Okay, you write in item number 38 and
41, service is complete.
okay, 38 and 41 you write as per the Lawazima court proceeding dated 7/5/2026, the service of notice upon respondent number 3 is complete. In 41 also respondent number 3.
Same, 38 and 41, service is complete.
Service is complete.
39 and 40, my lord, I'll have to take fresh steps.
Correct. And in 39 and 40 you write that the learned counsel for the petitioner will take fresh steps for service of notice on same respondent.
Or precedent, my lord, it is precedent,
No, respondent number. It should be.
respondent number, in one it is 2 and another it is 3, my lord.
You give the numbers.
I'll give the number.
You give the number which are the respondent. Otherwise, I'll have to check all the files.
I'll give the number. In a cheap.
Where this service is not served as yet. Okay.
I'll
We'll take it from you.
give.
Okay, list the matters after list all these matters after 3 weeks.
And my lord, there's an interim protection that needs.
Interim order so passed earlier shall continue, and he'll take steps by speed post as well as usual course.
Obliged, deeply obliged.
42. Lordship, this matter is impetuous after issuing the notice.
Hmm?
After issuing the notice, the respondent authorities are compliant. The relief was sought for, my lord.
Okay, right. Heard Mr.
Yes,
So and so the learned counsel for the petitioner. He submits that the matter has become infructuous as the relief sought for has already been received by the petitioner. He prays for withdrawal of the matter. The matter he prayed in view of the aforesaid submission, the instant petition is closed and disposed of.
I'm obliged.
Yeah. My lord, as per the Lawazima court's order, my lord, dated 18/5/2026, service against the respondent number 1 and 2 is complete. Application review ID. अच्छा, ये है, ये है। Yeah, yeah. Oh.
Okay, heard Mr. BK Sen, the learned counsel for the petitioner. It is revealed from the Lawazima court proceeding dated 18/5/2026 that service of notice upon respondent number 1 and 2 have already been completed. Later matter will be listed after 3 weeks for admission hearing.
The IA is for my lord restoration of the my lord petition which was dismissed for non-prosecution. That is the
Okay, in IA only, right? Huh? The order is passed in IA. After 3 weeks,
lordship may fix
or
it.
maybe 2 weeks. Let it be under after 2 weeks.
My lord, lordship may
No dates. No, it's 2 weeks. Let other party come. Other respondents come.
yeah, they should have come my lord today because service is complete otherwise. I'm obliged. My lord.
In this matter, my lord, compliance affidavit has been filed now.
Hmm?
In this matter, compliance affidavit has been filed, the order has been complied now. Annexure 1 is the sticking order.
Complied. Affidavit filed.
Yes, I have filed affidavit. Prayer for, lordship's,
What was the compliance you was, I mean, you have complied with?
lordship that pending application by which he has sought for striking out the names of respondents, my lord, that it was rejected, dismissed, my lord. So he has to file appeal against it, immediate, like. Lecture one is the order.
It has been complied with. Heard, Mr. You are
Okay.
Mr. Huh?
RK Moore.
RK?
More.
Moore, RK Moore, the learned counsel appearing for the petitioner. The instant application under section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, has been filed alleging non-compliance of the direction of this court passed in WPC number 1167 of 2025 on 12/3/2025. Full stop. Where is that order, High Court's order?
Next day 8, page 30.
Okay, you write, provide an order dated
12/3/2020.
12/3/2025 passed in the case of Richie Bora and another versus the state of Assam and 14 others in bracket WPC stroke 1167 stroke 2025. This court has directed
Era 9 is the direction, my lord, though it was, could not be complied within 10 days. Petitioner respondent has offered unconditional apology for that. As hearing was initiated by his predecessor.
directed that the dispute raised by the petitioner in UGUSH number 2023 stroke 5062 shall be brought to a logical end by the circle officer, not Gauhati Circle, Amingao, by passing an order within a period of 10 days from the passing of the aforesaid order dated 12/3/2025. Full stop. MS M. Bourbon, the learned counsel, appearing for respondent number,
Full response.
respondent for the respondent as respondent has submitted that that an affidavit has already been filed in the instant case wherein instant case by stating that the order the order dated 12/3/2025 has already been complied with by passing
Speaking of
by passing a speaking order dated
17/10/20.
17/10/25.
17/10/2025. Full stop. Full stop. Taking into account the aforesaid, the instant contempt case is closed and disposed of.
Obliged.
49.
My lord, there is a judgment passed by this court in bench of this honorable court only, my lord.
Hmm.
It says, my lord, these were the prior happenings
The alia is happening is prior to the election. So my lord, any order cannot be passed by the district administration for disqualification of an elected member. Only remedy lies before the election family. Hello, the para 78, the case has been let down.
But this has come for orders for what? We will check it up that.
Okay, ma'am.
You have not taken steps for service of notice.
Your Lordship.
You still want to continue with the petition or not?
Lordship,
See, he's saying that like there is some judgment passed by coordinate bench.
I can give the number.
That is correct also. I mean, now it is, you'll have to, if you want to challenge this, then you have to file different petition. What is to be done? You want to withdraw or you want to carry on with this matter?
WPC 7351.
I'll be allowed to withdraw, Your Lordship.
You'll be allowed to withdraw. Do you,
Instruction. Withdraw.
Hmm?
You just go through this judgment once. 7351/25. WPC 7351/25.
okay, we'll put it on Monday. Monday we'll put it up. So Monday we can probably, if she's agreeable,
Yes.
after going through this,
Yes,
we
yes.
can dispose it of.
Yes. Para
Okay.
78.
Heard, MS, your name?
Adopt.
25.
R. Datta, the learned counsel appearing for the petitioner, also heard Mr. NC N. Das, the learned counsel appearing for the state respondent as, please speak a little bit louder.
Respondent one.
NB Kayastha, MS NB Kayastha for respondent number 1. Full stop. Let the matter be fixed on the prayer of the learned counsel appearing for the petitioner, let the matter be fixed on 25th. You please go through it, madam. You go through it, then if you think that there is nothing remains in the matter, then we can close it.
50.
Remedy section 144 CPC. Then also it's order.
Hmm?
This fixed for order, madam. Remedy.
I file a petition IA for
I for what?
IA for implementing the civil judge senior division, but as part of the number 40.
Civil judge?
Yes.
During the
How?
pendency of the case, my lord.
My lord, I
execution
shall
took
read
place.
place.
Hmm.
Remedy is there if he can come successfully in the appeal, section 144 CPC.
Hmm.
Restoration.
But how can you make a civil judge a party?
Well, it is a read petition. If
copy
fact
has
is-
not been-
But in a writ petition also,
I know, fact is there. The civil judge senior division person stay order.
okay, I mean, this has come for what now? Today is for what?
So for implementing a party respondent.
And have you notices are served?
Copy not
Copy,
served.
sir.
Huh?
Copy.
Notice, so copy served?
Copy, sir.
Oh, no. আমাক কৰা নাই।
No proof of serving the copy of AC writ petition received in the section till date.
Not sir.
Hmm.
Why should I tell you?
Not served.
এইটো আপুনি 7126 ৰ যোনটো ফাইল কৰিছে সেইটো আছে।
এইটোৱেতো। This is a copy.
আয়ে কপি।
But you haven't filed any proof of service before the section.
They are admitting.
No, this has been sir.
They
They told it today, man.
Today
The
no.
date has been admitted 7126. It was sir.
Then
Let it
I
come up
file-
next week, my lord.
No, then I file a contempt petition there.
We'll put it up in the next week. Today, I mean, it will take some time.
Contempt
No,
liability in
only
execution.
my lord, last, earlier matter has come before this honorable court, directed me to implement the concerned civil judge as party respondent.
Where, which is direction?
First order, initial order. is-
1 second.
That is why I filed this petition.
থাকিব পাৰে, কিন্তু এইটো তোমাৰ ডিভিশ্যন হৈছে, এইটো প্ৰপাৰ্টিটো আপিলত যদি সাকসেসফুল হয় তেতিয়াহ'লে সেকশন 144 লাইক কৰে সিৰিয়াসলি কথা।
Because instead of stay order, the eviction, poison handing over, my lord. So I filed a contempt petitions. That petition have not been accepted, my lord. That is I come here, my lord. It is the duty of the civil judge to accept the same and revert the matter to the honorable high court, my lord, for take up the matter for contempt proceeding against the bailiff.
Can it be next week, madam?
So there's an order.
Next week, madam. I'll go to Monday, madam.
No, there is an order to implead him. Then where is the question of your this thing?
There.
Objection.
Listening. You're there.
Oh.
The order is there. Unnecessary objection.
See, he has earlier made
my lord.
civil judge senior division Borpeta
Okay, my
a
lord.
party instead of learned district judge Borpeta. So court has allowed him to file
Yes, yes,
file
yes.
a IA, making him a
Yes, yes,
party.
yes.
So there is nothing
No, nothing
remains.
much.
Okay, heard Mr. J. Ahmed, the learned counsel, appearing for the applicant. Full stop. Also heard Mr. N. Das, the learned counsel, appearing for
My lord, I'm appearing for the 3456.
3, 4, 5, 6, and
For Lordship, 2, 7 and 8 Lordship. On behalf
Your
of
name?
Mr. N.K. Sharma Lordship.
N.K. Sharma on behalf of.
Mr. H.K. Senior counsel standing on the Gauhati.
Okay, so, nah, right. Then you write.
In the
But-
read petition, I'm appearing for my lord. 3, 4, 5 and 6.
And in this application,
Application, my lord. Same name.
same.
Same.
In this application, then you write in the connected writ petition, wide in order dated 18/12/2025. This a coordinate bench of this court has allowed the applicant to file an IA for impleading civil judge senior division Borpeta as a party instead of district judge Borpeta as a party respondent, full stop. In view of the aforesaid direction, the instant IA has been filed by with a prayer for impleadment of the district impleadment of civil judge senior senior division Borpeta, full stop. The prayer of the applicant is allowed, and the instant IA is disposed of with a direction to file the amended cost title in the instant amended cost title in the connected writ petition. Full stop.
Respondent number 14.
As respondent number
14.
14. Okay. Let the matter be listed after 2 weeks.
Next week, as in is there.
Next week, what urgency? 2 weeks after 2 weeks.
That may be fixed, my lord.
Better you do.
Can it be earlier, my lord? First week of June.
No, that will differ. A lot of matters are there. What is the urgency?
Urgency because, my lord, my house has been taken away. Illegally evicted from the house, my lord. We file a contempt petition because this my petition has not been taken. It is the duty of the civil judge to register a contempt petition and refer the matter to the High Court for taking draw up a contempt proceeding against the officials. But same has not been done, my lord.
Okay, let it be on 11 June. It will not be possible today.
Yes. My lord, so
The inquiry report that was, my lord, before Lordship may fix a date for.
Then you write, heard Mr.
K. Bhattacharya.
K. Bhattacharya, the learned counsel appearing for the petitioner. I'm also heard Mr. B. Goswami,
What is state respondents?
state for B. Goswami, the learned senior counsel for
State
as a additional advocate general for state respondents. Anybody else is appearing?
I'm for respondent number 6 on behalf of state.
So and so. You give all your names, huh? Give me your names. Okay. Let the matter be listed. When do you want? After 2 weeks,
If yes, I need to stay, my lord.
then it will go to,
Tuesday of Thursday, hearing day, because it.
okay, 18 June, 18 June,
My lord.
18 June. Oh.
Oh.
सर्दी लगती है, एसी चलने से ठंडा लगता है, तबीयत खराब ऐसे गड़बड़ है, यानी थोड़ा कागज करता है, नहीं रखते हैं कि सुबह में आते हैं तो रात को अलमारी नीचे था, आज में कागज लाया है,